admission, madam. I prefer 1 week after.
Urgent. Yes.
Item 64, this is compromise matter. Last occasion, this one directed to appear and file the affidavit, my lord. In the meantime, the council, the petitioner changed, my lord. His power not name was not reflected. That's why not will file the affidavit.
Next week?
8, my lord.
8.
Because
My lord, item 69, my lord. I prefer.
Press matter.
No, after notice matter.
Where is the other thing?
I am for the petition.
Interim order is there.
Yes,
No position.
I am for the petitioner. Please to taking time.
On the request of
Pardon your worship.
opposite part.
Lordship, item number 7. Lordship has directed both the parties to appear before this court. Lordship, meanwhile, the
1 minute.
petitioner.
Interim order to continue. Take it, huh?
Item 69.
69.
Lordship, in item number 7, your Lordship has directed both the parties to appear before this court. Unfortunately, the petitioner has broken her leg, your Lordship. May I adjourn it to after vacation?
After vacation.
Obliged.
My lord, item number 65, I am in VC mode, my lord.
Mr. Hon'Ble, also requested for 2 weeks time. There is no stay order. Item number 5 is time. My matter 67 matter has been settled. There is some part payment is to be made. I have also talked with the petitioner council. Your lordship, I am for the wife. Lordship grants 2 weeks time, so that we will file joint affidavit after payment, part payment.
8. 8, 9, sir.
Item 67. Mr. I have talked with the written consent. Interim order is there. Let me continue.
Interim order to continue.
8.
Pardon, my lord, item 68, my lord. 2 weeks time for my senior is accommodation.
Fresh matter?
No, after notice matter.
Where with the other side?
Other side को inform करी.
No. Tick mark रखो, we'll see.
Pardon to
When
mention,
the matter will be taken up, we'll see. If nobody comes.
pardon to mention, your lordship, one item had come, one CRLMC number 820 of 2024 had come before your lordship on 9/4/2024. It was a quashing application of 138 proceeding. Your lordship was gracious enough to issue notice in that matter, but stay application was not had since I had failed to submit all the documents. Thereafter, I have mentioned to hear the interim application. Obliged, lordship.
Item 70, inform file an affidavit to settle this matter.
Sorry?
Inform file an affidavit to settle this matter.
Which item?
Item 70.
7.
70.
70. You want adjournment?
Yes, my lord.
Compromise.
Item 70.
Compromise. The parties are there?
No, my lord.
No. Is there any stay?
Last occasion is file an affidavit.
No, stay is there.
No stay.
If there is stay, then I'll vacate. On the ground of settlement, you take stay and thereafter you keep on. Yes. Next.
May I seek your Lordship?
Yes.
My lord, may I mention in VC mode?
Yes. Yes, Mr.
My lord, item 65, there is a talk going on for compromise. There is no stay. Your lordship has not granted stay, only issued notice. Can it be after 2 weeks, my lord? There is no stay.
But the other side you have to inform, not that he will come and oppose it.
No, my lord, there is no stay. There is no stay. There is no interim order passed by your lordship. Your lordship had only directed for mediation, and mediation, I think that has been settled.
Take mark it and keep it. Okay, we will accommodate. Don't worry.
My
Okay.
lord.
Yes.
My lord, I am at Bhesti Tamalpur.
Yes.
My lord, I would like to mention the criminal miscase number 682/2024.
Yes.
My lord, this petition under section 482 has been filed for quashing of FIR, my lord.
Yes.
The case is absolutely civil in nature, and the case has been instituted.
No. What do you want? You don't argue the matter in mentioning state. What do you want exactly?
I want to.
You give your memo.
Yes, I
You
have
give
filed.
your
I
memo.
had filed on 5/10/2024. I had filed a memo.
We'll see. Tell the number once again.
Criminal miscase number 682/2024.
We'll see. What? Yes.
I may be.
May I seek your Lordship indulgence
Yes.
to mention?
Yes.
Criminal MC number 3696 of 2023, my lords, had heard this matter on 16, my lord.
I'm only praying for the order has not been uploaded of the judgment reserve. The matter is listed in trial court tomorrow. And the learned judge wants to see that the matter is concluded, my lords. And the judgment reserve, it has not been uploaded yet, my lords.
No, judgment is here.
Man, that passing matter, my lord. The builder matter.
That washing petition, my lord, where that society that.
Okay.
So I'm only praying for the order to be uploaded, my lords.
So that they will file the same.
Order judgment reserve, please, madam, because the trial learned judge wants to see that.
One line order, madam, that may upload so that they can able to.
Completed judgment reserve, that order.
That order he was.
Okay. Yeah, upload.
Only that order, my lord, that arguments concluded.
It will be uploaded by afternoon. It will be done.
I'm so grateful, madam. Sorry
Yeah.
for inconvenience.
It's all right. All right.
Grateful.
Pardon to,
That order upload. Yes.
my lord, the order of a
It will be
public,
done, Mr. Singh. It will be done.
I'm so grateful, my lord. Deeply obliged.
Yes.
my lord, the order of cognizance and enter criminal proceeding is under challenge, my lord. The petitioner is a social activist and the GR case number is of the year 2014. And because of this criminal proceeding pending in the learning court below, the petitioner fails to get a visa and other facilities, benefits, my lord. Therefore, this matter may,
Travel.
my lord, travel.
Social activities, a lot of work there in India. Why should you go?
Let it come, my lord.
See, we'll see how to.
My lord.
Yes.
I may be pardon to make mention, let's say, cognizance already has been taken by the lower court below on summons issue and filed the memo, let's simply release the matter.
We'll see.
Already.
Yes.
Much obliged.
Item 1.
What is this matter?
That's it.
Item 1 also, nobody comes for.
22 matter.
Senior counsel.
No. It's not senior.
Ashok Kumar Chaudhary.
Not us.
Oh, अच्छा. Ashok Mahan, sorry.
22 matter. In the year of 22 matter.
22. Old matter.
22 matter, na? वो pass out 20.
Item 2.
We want to finish all 22 pen.
My lord.
Fresh matter.
My lord, on behalf of the Tapas Kumar Acharya, kindly withdraw the document.
Withdraw.
Yes.
Withdraw.
Memo.
Withdraw.
Yes.
Yes.
Item 3.
Your Lordship, here we are challenging the order of cognizance dated 31/7/2023, passed by Learned Court of JMFC Cuttack in GR case number 1815 of 2020.
Cognizance order dated?
31/7/2023.
Yes.
Here, in this matter, the dispute arises out of a joint family property dispute. Here, the petitioner is one of the power of attorney holder, and there is a civil suit pending from 1998. There is a civil suit pending. During the pendency of the civil suit, the petitioner is holding the power. Petitioner
You continue. He will assist you now.
I will, man.
Yes.
The petitioner is holding the power of attorney. Here, the petitioner is supposed to collect the rents from all the properties that are there under the joint family property. So when the petitioner was collecting, accordingly, the petitioner was collecting the same throughout from the year 2000. In the year 2020, when the petitioner collected it from the complainant, the check actually bounced. So 1CC case was instituted, and when the summons was served, the FIR here in this case, particularly the case before this, was registered against the petitioner.
Yes. This is the story, but why do you, how are you challenging the cognizance order? What is wrong in it?
Your
You have to
Lordship,
satisfy the court insofar as the illegality, if any, in the order of cognizance, because you are challenging. See, come to the cognizance order.
yes, sir.
That is at page 12. Okay.
Yes, sir.
Now come to the charge sheet. Whether just see the charge sheet.
Yes,
If
sir.
any case is made out, court has rightly taken cognizance.
Your Lordship, but here the case is that the petition number 2
what he's the brother of the complainant. The allegation is that he has taken 6 number of checks from the room of from the room of the complainant and given it to the petitioner, and they have encashed the check accordingly. Here, there is no witness with regards to the fact that anybody
All
has.
these things, the trial court will look into. Trial court will look into. Just see, come to page 35
Yes,
in the charge sheet.
yes, yes, sir. I'm there.
You are Jagat Jivan Prasad, huh?
Yes,
Jagat Jivan Prasad.
Yes, Lord.
Come to page 35, the charge.
yes, Lord.
Read it out. What are the allegations against you? 35.
During from the paragraph, during the course of investigation, I examined the complainant and other available witnesses who will prove the occurrence. Spies were engaged to get clue about the accused person. In course of investigation, it came to the light that the complainant Lingaraj Prasad is running a foreign liquor shop designated as King Baba at Bakshi Bazar, Cuttack, over plot number 281, 282, Khata number 469 of Moja Unit 11, Odia Bazar, Cuttack. License primarily issued by from Government of Odisha in the name of Chandra Mohan Prasad, father of the complainant. The shop, which is situated over the plots, is jointly recorded in the name of Chandra Mohan Prasad and co-sir. Complainant Lingaraj Prasad and FIR named accused Gajendra Prasad are
I think we will issue notice because there are family disputes, basically.
Minor.
We'll issue notice.
And also suit is pending.
Suit is pending and all. Issue notice, returnable within 2 weeks. Notice to opposite party number 2.
Your Lordship, there is an IA for stay of proceeding.
Write down, learn counsel for the petitioner. What is your full name?
Prayas Mahanti.
Huh?
Prayas Mahanti.
Prayas Mahanti, learn counsel for the petitioner submits submits that the dispute is dispute is in the, and this is a family dispute between the brothers.
Between the brothers and uncle.
This family dispute between the brothers and uncles, and civil suit is pending relating to the disputing subject. वो तापर issue notice कर दियो in the internagnum the further proceeding. Once you stay, then you will ask for adjournment. Okay, further proceeding in so and so case. It said
Till next date.
or till next date.
Statement
Next
fixed.
date, it made clear that no adjournment shall be granted.
And this case will dispose at the time of admission.
No,
That's what
no adjournment shall be granted in this matter, and the parties would explore the possibility of settlement.
Yes, yes. Obliged.
What we'll do is we'll send it to mediation. Let them come. That's all. Family dispute.
Item 4.
Item 4 may kindly pass over, my lords,
Okay, pass over.
after lunch.
Item 4.
Pass over. Pass over. Na?
Pass over after
Yes,
lunch.
yes,
Next week వస్తున్నారు.
next week.
Ah.
Mr. Marana is seeking adjournment.
Your lordship,
For a week.
tomorrow if possible, your lordship.
Tomorrow I will be
Tomorrow.
absent.
He
Okay.
has some personal difficulty.
Your lordship, next
Huh?
Friday,
Next-
next Thursday, next Thursday.
Next Friday.
Third.
Most of it.
Six.
May I please? Here, my lord, the petitioner challenges the order passed by the learned SGM Bhadrak dated 26/4/23 in allowing petition under section 319 CRPC, which was also subsequently confirmed by the learned session judge. What happened in this case, my lord? Including the informant, has uttered a single word against the petitioner. I have annexed all the 161 statements, certified copies. But during trial, my lord, 1997, I was at the time of incident, I was appearing also close to science examination. Now I am a science graduate. And
What are the allegations?
allegation got a line, only one line in the FIR.
No, forget about 319 now.
Evidence was not.
Evidence.
Evidence
Copy
is-
evidence.
Evidence
On the
was
basis
not-
of evidence which has come on record during the
Yes, my
trial,
lord.
that something might have come. Therefore, we
He has
should.
not filed the copy of the evidence.
That
sir.
is necessary.
It required, my lord.
Let's make.
Forget about the FIR and everything.
Because-
That is the reason you have been exonerated by the police.
Yes, my lord.
And thereafter, when the evidence.
And
is recorded-
no protest petition was also filed.
That's right, but
Right.
not required. But in the evidence, if something might have come, so that is the reason 319.
Yes, my lord.
Just show me the evidence.
So here, my lord, family dispute, grandmother and grandson.
Everything is all right. What are the evidence against you? Let us examine that. Get the evidence. Let us for the petitioner seeks an adjournment to file additional document to substantiate his case, adjourned to. 319 cases, unless you file those evidence.
Yes, my lord, small debts, short adjournment. One, next Monday or?
He will accommodate according to the boards.
Yes. One
Accommodate.
chapter.
Item 8.
Please, Lords. In this case, the petitioner is a government servant and challenges the initiation of the proceeding under section 130 NI Act, my lord. And the impugned order is at annex.
Why have you issued check?
No, well, on the last occasion, I have adjourned this matter with regard to obtain instruction with regard to the payment of the check. I have already instruction, I have got the instruction. Lordship has
What
that
is
has
check
paid
amount?
2,50,000. That impugned order that is
Yes.
reflected at
Yes.
page 36, my lord.
Yes.
The accused issued check in favor of the complainant on different dates and in total tune of 2,50,000. Lordship got it. I have already obtained the instruction that more than 50% he has already paid and ready and willing to pay the rest amount also. That is my instruction.
You are challenging what?
I have challenged that on order under annexure 7. That
What is that order?
that 37. Earlier, I have moved before this Hon'Ble Court, and this Hon'Ble Court was pleased to direct me to raise all those grounds at the time of at the appropriate stage. That is at page annexure 5 at page, your lordship.
Yes.
29 mile.
Okay.
On the basis of which I filed a petition under annexure 6 mile. And with regard to that withdrawal of that order of cognizance and to dismissal of the complaint case, that was dismissed. That is under challenge. That arises at 130. Your lordship can issue.
On what ground you want watching?
My lord, prior to the complaint, this is a second complaint. Initially, the complainant has filed another complaint that is under annexure 1 series. That has
2
been
lakhs, check is 2 lakhs.
2,50,000, out of which I have already paid more than 50%.
Where is that? Where will I get that you have paid?
That you will, if a lordship will direct, I will file an affidavit to that effect. I have today morning, I have obtained instruction, and he has got the documents.
Issue notice. Then comes for the petitioner submits that he the petitioner is accused in 1 CC case number 2 of 2021 under section 138 NI Act for having dishonored the check issued by dishonored the check of rupees 2,50,000 rupees issued by him.
Beg your pardon, 2,50,000 different dates. Different dates. Yes.
In total.
Yes.
In total. He further submits that out of the aforesaid amount, he has already made payment of rupees.
More than 50%.
More than he has made payment of more than 50%. More than 50%. He would be filing an affidavit in this regard within a week. Within a week. Issue notice to the within a week. He is ready and willing to make good the entire payment to the complaint.
Yes, yes,
complaint. Issue notice to opposite parties also. Okay.
I have filed my lord. Short date, your lordship fixed short date.
I elected and comes for the petitioner submits that he would be moving appropriate application in trial court for an adjournment. Owing to the fact that the matter is sub judice before this court.
Obliged.
Move application and show this out.
Yes, ma'am. Obliged.
Item 9.
Item 9 and 10.
Yes.
Madam, may kindly tag both together.
Yes, no problem.
Item 10, who is the husband of the opposite party?
9.
Opposite party number 2.
9.
10.
Shall I take 10 first?
My lord.
Okay,
Both are tagged together, my lord.
okay, no problem. Yes, tell me.
Item number 10, item number 10, Devjyoti, who is the husband of the opposite party number 2.
Hmm.
And in item number 9, the petitioner, both the petitioner are in-laws, my lord. And I filed this petition under section 482 for quashing FIR, my lord. And allegation against the petitioner that 498A, 34 and section 4 of Dowry Provision Act, my lord. My lord, according to the,
You filed divorce petition.
my lord,
You have already filed divorce.
my lord,
Is there any chance of settlement?
no, my lord.
Why?
Because the lady who is alleged different things, and the situation is like that, that is nothing any possible.
That is the reason you should settle.
My lord, this, my lord has to
If
go.
the relationship is so hostile,
My lord.
you can't pull on. So settle and finish it up. After all, it's a matter of some money. You pay some money and get rid of her. If so, she is so bad.
The lady, the mentality of the lady is to harass the in-laws and the.
So why are you
husband.
subjecting yourself to harassment? Settle it. That's what I'm saying. If the lady is so bad,
But she is not wanted to settle all these things, my lord.
you talk about yourself. We will
No, my lord. Previously,
Yeah,
previously-
are you interested to settle?
my lord.
Is issue notice to opposite party in both the matters. Huh? Opposite party. Have you implemented that lady?
My lord.
Where is that? You have not implemented. Yes.
Opposite party
Srimati-
number 2.
Sunanda Pradhan.
My lord.
You have an issue?
No, my lord.
No issue.
Only there is 1.5 months she is resided with me, and the allegation like 498A, and the FIR is also on the face of record. 498A, section 34 or section 4 is not attracted at all.
We'll examine that. Let
My
it
lord.
come. Let her come. Huh? Issue notice. Huh? Opposite party.
Much obliged. My lord,
And file process, and we'll take in the next second week for you.
13th.
Then once she comes, I'll send for mediation. I will try.
Mediation.
date कितना?
13
13 और कितने?
यही मास हो you file the process fee, try to bring here, we'll see.
My lord.
We'll settle all the issues. Don't worry.
Much obliged.
Yes.
Item 11.
Tell your client, get ready for settlement. Get ready to pay alimony. You have to, pay some alimony.
If they want to settle everything, then
Eventually it has to be settled.
my lord.
Eventually it has to be settled because see, the relationship is such, you can't pull on, you can't stay together.
My lord.
You have filed already divorce petition.
But when the motive is
Forget about motive. You are not interested to stay with her.
she is
Let
not
her-
interested to stay with me, my lord.
Both of you are not interested. Forget it. She is very bad woman. Leave it. Leave her.
No, that's
How
why
does
the
it-
allegation is before this court, my lord.
Anyway, we'll see.
Much obliged.
Well, on behalf of Mr. Barrick Millard, kindly taken up on 7th May. In the meantime, the case record CRLMC 17333 of 22 may kindly be tagged with this case. Case and counter case has been, one case has already been, parties are present before this honorable court.
Is that matter is coming up on 7th?
My lord, so, no, that matter is passing. Case and counter case. One case has already been passed. Along with the tag with this matter, it has surgery already. 21 February 24 रे गोटे केस सर जाइए काउंटर केस टा खाली रही
So what do you want?
मैंने कॉल इट ऑन 7th मिलोड पार्टी जो
You don't decide the dates.
yes your
We
lordship's
have a
convenient
lot of things to.
your lordship's
when
convenient
Fixing a date.
on behalf of Mr. Barrick Millard I pray Millard
Urgent.
My lord.
Simply.
12. Item 12.
Will the matter be taken up after lunch?
Passover.
Yes.
Item 13.
Item 13 will kindly take up after launch, my lord.
Passover.
After launch.
Yes.
14.
May I please, my lords? Here, my lords, the allegation is violation of 276B of the Income Tax Act, my lords, for delay in depositing the TDS amount. my lords. I have given a chart to your lordships, my lord. Your lordship would see that the
What is the
delay, my
delay?
lord. Sorry, my lord.
Delayed.
Delay in payment of
No,
deposit.
ranging. What is the
My lord, ranging from 30 days to 100, your lordship would turn to page 11. 111 days, that
Have
is
you,
it.
have you deposited?
I have deposited the tax as well as the interest.
They're covered by my judgment.
It's covered by your two judgments, my lord.
It is less than 1 year.
Less than 1 year, my lord.
Covered by that circular also.
My lord.
I agreed with your lordship.
Your lordship can dispose it of unnecessarily. My learned friend also knows.
Let.
Lord, this-
Friday?
Let's.
Friday. He has a material instruction.
That today he can also have his material instructions, my lords. And then the disposal gives him more material instruction than taking an adjournment, my lords.
Could it be today? Friday means tomorrow. Monday?
Next Wednesday it will be better. We'll be getting the
Wednesday would be.
Do you have any? Let's see. You tell next week anytime because it will take 2 minutes.
My lords. That's your lordships have already held that.
Covered case.
My lord, covered by this.
But he has his own. He has to file Bokaratnama and.
No, he has filed it. He has filed it today.
So why do you ask for time?
So in this case, we have to verify the things also.
No, your lordship. No, your lordship may kindly.
Senior will be taking.
No, your lordship may kindly turn to the launching of the prosecution.
Nothing is required to be seen. Your case is covered, but he has his own problem, you know. Let it be Monday. Tuesday, Monday, whatever.
Monday, Tuesday, Wednesday,
Wednesday. Wednesday.
Obliged, my lords.
Because he wants to engage the senior counsel also.
Right.
You know.
Obliged, my lords.
Item 15.
Yes. In this case, FIR lodged under section 498A, 304B, 302, and 34 of IPC and 4 of DP Act. Here, the accused persons are husband and the in-law members. Those are the mother-in-law and sister-in-law. Here, what happened? Initially, one preliminary charge sheet has been filed.
Now, who is the informant?
Informant is the father, that is Ramachandra Pradhan. Is the father.
498A and all.
498A.
Why have you not implemented her?
Well,
you should have implemented the informant, the lady.
No, here what happened, not compromise, Here,
Till 498A, you have to implement this.
No, husband is.
It's a case 304B, 302, 498. The husband has been acquitted.
Acquitted.
Husband has been acquitted. So for the other petitioner concerned, they are paying for quashing on view of that. The husband.
They were
The principal accused.
Yes.
Principal accused,
My submission, that is your submission.
Yes.
My submission before the lordship. So for the, I'll go to the merits of the case. ABL appeal, anticipated appeal has been filed. First or second order judgment, but that has not been completed. Number one. Number two,
I mentioned
the evidence which has been adduced by the trial court and it has been assessed that nowhere a single word has been whispered that the husband was present at the time of occurrence where the incident is 100% was injury. So
therefore, the presence of these people may be there.
maybe that is my also.
Yes.
so far
Yes.
as the FIR and other connected papers are concerned, the allegations are omnibus in nature, and there is nothing, in the judgment that only husband was not present and others.
Show me any paragraph of that judgment which will render help to you. Show me.
Let it be taken up next week, I will comply. Next week, any day.
But only thing is, see the evidence.
Because the judgment, only
Next
confined
week
to the husband.
That is the whole difficult. That's what
Well,
it says.
what depositions will bring all the
So it is basically a case of alibi in the part of the husband. He was not
No.
present in the spot.
Because I will
And
file
in
the
case of
deposition.
death, in the case of death, who was present, what had happened?
That depositions will say, I will file the copies of deposition and will supply,
If something comes out, then why not?
Yes.
Something comes out.
Your lordship may direct to file depositions and
Learned counsel for the petitioner seeks time to file additional document to substantiate his case, lease the matter.
date may kind of.
He will give it.
Right.
Yes.
16.
Kindly pass over, my lord. After launch, my lord. Okay.
17.
May I please your lordship? I am in VC mode, my lord. I'm in VC mode.
When are you coming to the court?
My lord, after 10th, my first checkup, I'll be okay, my lord.
Okay.
Your lordship may accommodate till 10th or 11th.
Okay.
Till 10th or 11th, your lordship may kindly accommodate me in VC mode.
Okay, it's all right, no problem. Yeah.
My lord, here the institution is before your lordship, which is a private college and a trust, my lord. There was a dispute between OP number 2 and the petitioner, and which was confirmed in second appeal, and both the persons were found to be trust members. Thereafter, during pendency,
ଆପଣଙ୍କର ଅଫ୍ ହେଇଗଲା
my lord. One CC
I,
case.
I couldn't hear you in between. Yes.
My lord,
Yes.
during pendency of the first appeal, when the trust members were in dispute, a 1 CC case was filed against me. Thereafter, ultimately in the second appeal, the present petitioner was found to be the trustee, and he has taken over the charge, which was confirmed by the Honorable Apex Court.
Second.
In the meantime, in the second appeal,
I'm
in a
not able to
second
follow.
appeal, my lord, there was a dispute between two trustees, the OP number 2 and the during pendency of the first appeal.
No, the problem is there is no OP number 2. Therefore, I'm confused.
Yes, OP number 2 is dead in the meantime. The complainant is dead in the meantime.
No, where is OP number 2? You have not implemented anyone.
Yes, my lord. I have implemented Govinda Chandra Naik.
Second page.
It is not there with me. That's why.
Scan.
Not there. That page. Oh, page number 1 for 3
1 for
29. That is why I am confused. What is that?
Yes, my lord.
1 for 2.
What's the? Oh. Yes, OP number 2 is Govinda Chandra Naik and Hemant.
Who is dead in the meantime. Before death, there was a compromise effected between the parties. That was in a criminal division. Your lordship may kindly turn to annexure at page 17, where the parties compromised the matter. After that, he died. He did not take over the charge pursuant to the second appeal. Now, my lord, after was taken 2015, in 2024, a notice was issued to me that you appear in summons. The summons is at, my lord, annexure 4, page 26. The summons were issued on 11/3/24. Now the complainant is dead. Before the complainant died, the parties have compromised. In the second appeal, I have been found to be the valid trustee, and I am in charge of the trust. And this has been done after, my lord, lapse of 9 years. 2015 cognizance, 2023 notice has been issued when after the complaint.
Yes.
Your lordship may kindly see. First of all, my lord, the charge sheet copy has not been filed in this case. Only the affair. Number 2, revision application revision application filed for which trial is delayed, and they have been directed to appear. Till date, they have not appeared before the trial court. Revision application, your lordship may kindly see. A revision application in the year 2008, it has been filed, and it has been dismissed.
Okay,
it has been dismissed on.
On 15/16.
Yes.
And see, there are a lot of complicated facts. 1 minute, Mr. Bose. There are a lot of complicated facts and all. So you are coming after 10th. You are coming to the court.
Yes.
Let it be on 15th.
My lord, your lordship may issue notice to OP number 2, OP number 3. OP number 2 is dead. Your lordship may issue OP number 3 notice.
Notice, let
Okay, issue notice to opposite party number 3. Opposite party number 3. Okay.
And my lord, I am praying in the meantime. Now I am on bail. There is no issue on that. I have appeared. I am on bail. your lordship may stay the further proceeding of the proceeding.
No further proceeding stay. If you want to insist on application, then 15th you come and satisfy me.
Yes.
Bring her out. I am
Yes, yes,
issuing
sir.
notice 15th. Keep her on 15th. Okay. Simply issue notice. Yes.
Item 18.
My lord, in the next item, your lordship may issue notice to opposite party number 2 and 3.
2 and 3 opposite and same 15th.
Yes.
Yes.
20.
My lord, one thing just I'll bring it, lordship. My lord, here I have already appeared, which my learned friend is not correct. I have appeared and I am on bail. I received the summon.
Nothing. Heaven is not going to fall within 1 day. Within 15, the trial is not going to be concluded. You bring them.
No.
See, you bring them. I have issued notice. You bring them. If any possibility of settlement, we'll try and finish it up.
Yes.
That's the idea.
That's the idea.
That's the idea.
Yes,
You are on
yes,
bail.
madam.
There is no
Yes,
threat for it. What is the guarantee?
No, that's not
Bring.
there.
Sir.
Yes.
Your
Sir.
lordship issue notice item number 17 to OP number 3 and in 18 OP number 2 and 3.
Yes, yes.
Okay. That is done. That is done. Okay. Yes.
Item 20.
May I please your lordship? Lordship, it's compromise matter, lordship.
19 that.
Lordship,
ଥିଲା କି କଣ 19 ରେ କିଛି ପ୍ରୋବ୍ଲେମ ନାହିଁ ନା
नहीं सर फ्रेश केस टा मु कहदम सीधा
Lordship, it's compromise matter, and I filed a compromise affidavit in Annex 1, Lordship. The connector matter was listed on yesterday, Lordship, and your Lordship adjourned that matter to the next week. So my prayer before your Lordship is kindly list this matter on the next week.
which one is the corrected matter
1187 of challenge.
1187 ସହିତ ଟ୍ୟାଗ କରିକି ଲଗେଇଛି
1187.
Okay.
24.
24 ତା ସହିତ ଟ୍ୟାଗ କର ଆଉ ଯେବେ ଆସିଛି ସେଦିନ ଲଗେଇ ଠିକ
Obviously.
21.
but bring the parties
Lordship.
on that day don't ask for adjournment
No.
yes
Petitioner challenges the order dated 23/2/24, the alternation of a charges under section 12 to under section 8 of the POCSO Act.
what is this
By the exercise
was
of
the order of alteration
Yes.
23
under section 216 of the CRPC.
what is this order
Petition
Mr. Maharaj
number 1 is practicing.
She along with her husband convinced different self-help women group of the of Kendrapada and convinced them to deposit 2,100 per person
Each.
and 21,000 per group in the state organization and promised them after giving such amount promised them to give good returns. In this process, they have the accused persons have collected about 84,000 from the different to women self-help group. Therefore, the FIR was lost. FIR was lost. The charge sheet was filed.
Charge sheet was filed. I have
Yes,
Annex 2.
charge sheet was filed in this case on 28/2/2013.
13 years.
Charge not framed.
No, my lord.
When the
Trial has been stayed. The stay has not started, my lord.
before the trial could start, trial could commence. The parties have settled their dispute and petitioners have filed the present petition before this court. The petitioner, all the petitioners are present.
Yes, my lord. All the petitioners they filed application.
The petitioners and opposite party number 2
And others groups also.
and are present in the court, being represented by their counsel and identified by them. They have also filed the self-attested copies of their Aadhaar card, which are taken on record to establish their identity. The petitioner and the opposite party number 2 filed separate affidavit dated 89. Date, where is the date of this affidavit?
Petitioner date
Dated 22/4/2000.
25 signed.
And it is attested on 24.
Acha.
Otherwise, there is no date given.
Yes, yes.
So 22/4/2024. Inter alia stating that the money collected by the accused persons from the informant and the other self-help groups to the tune of 84,000. 84,000 has been returned to the respective claimants. And thereafter, the parties have compromised in this matter, and on the ground of settlement, the opposite party number 2 submits that he doesn't want to proceed with the matter against the petitioners. Mr. Maharaja appears for the state, submits that the dispute is inter-se party, and since the parties have settled their disputes, and the disputed amount has already been paid to the informant and the other claimants, there is no legal impediment in quashing the FIR. Moreover, the parties have settled their dispute and filed respective affidavit before this court. Therefore, subjecting the petitioner to trial would be a futile exercise. In view of the judgment of the Supreme Court in Jan Chan so the present petition deserves merit according to the FIR and so. Yes. Next.
23.
Yes. You are there?
Yes.
Yeah.
The impugned order is annexure 4, page 21 errors.
4, huh?
Yes, my lord.
Yes, what is this?
See here, what happened in this case lord, is on 23/11/2023. The DW1 is a case of your also 130 NI Act. DW1 has been examined.
You are accused.
I am the complainant.
Complainant.
Yes, my lord. So in course of his examination, he produced certain document that is in marked as exhibits. So it has not been made objection on behalf of the complainant because one of the junior counsel was there, lords. In the later stage, lordship, application is filed. That application here, lordship, that is annexure 2, page 18. That the document has been filed by the DW1 has been marked as exhibits. That should be with objection. It has been submission of the complainant. That has been rejected by the London Court below. In the similar fact, lordship, glance, annexure 5, page 24.
You want to
that objection has to be with objection.
With objection.
Exhibit has already been made. I prefer that should be with objection. So similar.
Your junior counsel could not mark that.
Yes, my lord. This is my plea. And court has also been stated also in the order.
Issue notice.
And I also have a glance, annexure 5, also page 24. Same thing is happened so far my case is concerned. I became a complainant when I examined, filed certain documents, and the document has been exhibited. Defense has not been marked as objection. Then he filed an application that has been rejected by the court below. Again, he approached before this court. And these
are directly covered by this.
Allowed. Yes, yes, my lord. Yes.
The fact circumstance difference हो जाती 138 के मैं कोई
The accused has to come in any case.
No.
Let the accused come.
Yes, yes.
Accused come. Issue notice.
Yes.
Issue notice, returnable 2 weeks कर दियो. You want to stay?
Any date may can fix and specific date. You must stay. Maybe your trial is proceeding.
You are complained. It will be stayed.
And say therefore, I mean a specific date may can fix till such date stay will continue. The matter will be listed
Stay
automatically.
is detrimental to you only.
If your lordship trial in the meanwhile continuing in ended your lordship, then ultimately my file will become infructuous.
Right. The confident petitioner submits that he has marked the petitioner is the complainant in ICC case number
20/2018.
20/2018. under section 138A9. He has, the learned counsel for the petitioner submits that during trial, the complainant has exhibited the document. However, he could not mark the objections in the exhibited document. The complainant was represented through a junior counsel who missed this aspect. Therefore, he moved an application before the trial court, entirely praying that he may be allowed to
Object this document.
allowed to endorse in the exhibit his objections, which was turned off. Hence, he has approached this court. The learned counsel for the petitioner further relies upon the judgment of a coordinated bench dated order of coordinated bench dated 2/1/2023 passed in CRLMC number 4024 of 2022 and submits that his case is clearly covered by the order of the coordinated bench. Issue notice to the opposite party written within 2 weeks. In the meantime, further proceeding in ICC case number 20 of 2018 is stayed.
Specific date you'll also make any
Specific
fix?
date will be given.
Oblige yours.
Yes.
34 अच्छा ये 16 टा क्वेश्चन पड़ जाता है जो compromise
Compromise उठाएगा 16 मीटर रही है पास है
Could have.
This is item 16.
Action the party action.
ଆସନ୍ତି ଏଠି ବୁକ୍ସ ଅଛି ଆଉ 164 ଷ୍ଟେଟମେଣ୍ଟ ଫାଇଲ କରିନାହାନ୍ତି ଭିକ୍ଟିମ ଆଫିଡେଭିଟ ବି ଫାଇଲ କରିନି
ହଁ ଫାଇଲ ହେଇଛି ନା
that is it number 1 and on that day also Lordship, provided that the seized property shall not be released during pendency of the confiscation proceeding or trial even on the application of the owner of the property for such release.
50, you are reading 56.
56, my lord.
Of
Orissa Forest Act.
Forest.
Right, my lord. Now, my lord, Lordship may kindly turn to page 21. Page 21.
21.
Challenging that order, I have preferred the application before the Honorable Sessions. Revision. Your Lordship may kindly turn to page 21. Lordship got it?
Yes, I got it.
Page 21. Last 3 lines. Hence,
in reply that paragraph.
Yes, in reply. Hence, a revision against that order is not maintainable in the view of the bar created under section 3. So, revision is not maintainable. That is on only that ground, my application has been dismissed. There is no such. It should have been discussed the merit of the case. I don't have any objection. Order may be passed, vehicle may be released, but I don't have objection. But my question is that application should have been considered. It is not maintainable. Division not maintainable. Your Lordship is a day and a day. Your Lordship is passing many orders. That is my whole problem, my lord. My grievance.
Let the revisional court
assess it. Considers.
My lord.
That is the application.
Your Lordship, I am the sole opposite party. I am giving.
Now, what he says that the revisional court has not applied the matter, saying that it is not maintained.
The revisional court has rightly stated that. Why I am saying so, my lord?
Yes.
Before going to my lord.
What is this?
My lord, it is a. I have. I am narrating, my lord. I have filed. My vehicle was seized by the forest office. I filed a 457 application. That was released by the forest department, basing upon our High Court order, High Court judgment, my lord. That is Arun Kumar Agrawal versus State of Odisha by Honorable Justice A.K. Mahapatra. He has relied upon the decision and released the vehicle, my lord.
Arun Kumar.
My lord. Arun Kumar Agrawal. That is same case, my lord. That was 5 forest days. Since
where is that Arun Kumar?
My lord, that decision. Before going to that, my lord, I am facts. I will, my lord, facts. Your lordship.
Achha.
Your lordship had order dated 5/6/2023. Will not a decision release the vehicle.
5/6?
2023.
Okay.
1 year back. My lord, on 23/6/2000, he has directed some condition. I have fulfilled that on 23/6/2000, intimate bond, 5,50,000 on other condition.
I have deposited the same on 23/6/2023 and a lot of decision directed release of the vehicle in my Jima, my lord. Your lordship, I have given that my page 19, so page 19, my lord, can have once.
Yes,
Your lordship got it?
yes.
On 23/6/2023, my lord, in compliance with the order dated 5/6/2023, I have complied with the order, my lord. Next page, my lord, on 27/6/2023, my lord. Sorry, my lord, he has not released the vehicle. The ranger has not complied with the order. I have asked for show cause. And page 21 of that brief, my lord, order dated 1/7/2023. Your lordship, last letter, my lord, 6:15 PM. Lordship, got it?
Yes.
A memo number bearing such and such received from the range officer, Fulbani Forest Range. He has intimated to this court that it is difficult to release the seized vehicle in favor of the petitioner. A call for a show cause from the range officer, Fulbani Forest Ranger, regarding non-release of the seized vehicle. He has not, my lord, obeyed the my lord, direction of the court below, my lord. After that, my lord, I have challenged the same, my lord, since he has not released the vehicle. I have filed in a CLMB application. In the pendency of CLMB application, London State Council stated that criminal revision number 2 of 2023 is pending. For that reason, so the CLMP, my lord, was
That revision is the order passed and we.
that revision part they have challenged. Your lordship may kindly have a glance to page 24.
24.
My lord.
Yes.
Assailing the correctness, legality of the order dated 23/6/2023 by the London Sub-Divisional Magistrate Fulbani, in which case revision has been prepared. He has not challenged that release order, that main order 5/6/2023. The order was passed on 5/6/23. I have given the independent bond and that condition, my lord, on 23/6/2023. He has not challenged the main order.
The 23/6/2023 order is a consequential order.
Yes, my lord.
Consequential order.
Yes,
Why should I file? The main order I have challenged.
Main order not challenged.
This is the order. This is the order.
No, no.
That your lordship may kindly
See page 24. Where
24.
Let us see.
ତମେ ସେଇ ରିଭିଜନ ଅର୍ଡରଟା ଦେଖୁନାହାନ୍ତି ପାରାଗ୍ରାଫ ଫାର୍ଷ୍ଟଟା ୱାନଟା ଫାର୍ଷ୍ଟଟା ଦେଖନ୍ତୁ
Hey, page 18 ଆସନ୍ତୁ.
ହଁ ମୁଁ ଦେଇ ଦଉଛି
Page 18. What he says is, page 18, if you see at the top,
ରିଭିଜନ ଅର୍ଡରଟା
the
ଦେଖନ୍ତୁ
correctness and legality, you have page 18 of your.
Yes. Assailing the correctness.
Correctness and legality of the order dated 23/6/2023.
Yes.
The learned sub-divisional magistrate Fulbani and so.
That is the important. The revision has been preferred. So my point is, my lord, I may be, my lord,
Now you
I don't have any case.
See, you may be correct in the sense that the revisional court has non-suited you on the ground that it is not maintainable.
No,
That is
not
your grievance, basically.
Yes, only.
But if they are covered by this judgment of our High Court in Arun Agarwal, why this exercise again? Maybe maintainable, may not be maintainable. Why to undertake this exercise?
No,
you tell me whether he is covered by this judgment or not.
Who dissented?
Arun Kumar.
ଅରୁଣ ଅଗ୍ରୱାଲ ସେଥିରେ ଲେଖା ହେଇଛି ଇଏରେ ସେଇ
Arun Kumar judgment ଦେଖନ୍ତୁ.
my lord, thereafter, my lord, my 1 minute, my lord, thereafter the revisional order passed on 4/12/2023.
No, it is maintainable to.
Just a minute. 4/12/2023, the revisional court dismissed the appeal. December. For the last 3 months, they have not released. I have preferred again the CLMP, my lord. Your lordship.
मेरिट को जाऊंगी आगे. मेरिट को आगे जाऊं. ये क्वेश्चन मोर.
Your lordship.
ये जो डिसीजन फाइल है 1997 रो. ये डिसीजन मेंटेनेबिलिटी ऊपर फाइल है.
Mental, you have not challenged the main order. You have challenged the subsequent order.
वो order कौन अछि? Say the last.
That is the constitution.
The revision petition is not maintainable.
So for that reason, you have not challenged the main order.
Whether it is maintainable or not maintainable.
I have filed a CLMP application. In the CLMP section 4/4/2024,
this should be considered a merit.
When they got the notice, my lord, after that they have filed the 482 application on 18/4.
There, your lordship, before your lordship. The statutory provision is there. I am not on that. I don't say, my lord, anything.
And your lordship, on
it is to be.
It was listed on 23/4.
I know this happens because the pressure from this court to comply the order,
My lord.
let them to file the revision.
Madam?
Let them to file the revision. Otherwise, they would not have filed the revision at all. Because there
Yes, 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 yes.
there was a
madam.
pressure, continuous pressure.
My
So
lord.
therefore, what to do? They went for and filed.
Revision.
But you tell me whether you are covered or not. If he is covered by this judgment, then the entire exercise, whether revision is maintainable or not maintainable, we need not go in the rigmarole again and sending him to revisional court, and again this revisional court will say that he is covered. You tell me whether any judgment covers his case or not. That's all. Because many times he has come to this court by filing CRLMC, blah blah, all these things. So why to send him back to the revisional court? If he is covered under 482, I will allow. If he is not covered, I will dismiss.
No.
You think that this is the revisional court? I will hear on merits. Forget about. You satisfy me. If you on merit, if you satisfy, he doesn't have a case, I'll set aside the entire thing. Why to send him back to revisional court? Unnecessary burdening. You satisfy, I'll give you time. Let's see the judgment. You satisfy.
He already know. My learned must know the.
Okay, your whole submission is the revisional court has not decided the case on merits.
Merit. What's it?
He should have decided.
Yes.
Okay. Forget about the revisional court. I am going to decide on merits. Why to relegate you to the revisional court? You satisfy me on merit. If you have a case, because see, many times he has traveled to this court. Just see, have you given this?
Yes, ma'am.
And this
my learned
was listed many times.
My learned
And serious observations are made.
Yes, madam.
And it says that prima facie, if the allegation is made is correct, this court disapproves the manner in which the rule of law is being flouted.
Yes.
Despite the order, you have not complied. So therefore, he files.
No, not compliance only. Not
because you say that revision is pending.
Yes,
subsequently.
that is.
When the revision filed?
You're also making.
And the date of filing revision.
Yes.
That was after that after dismissal of the revision.
This is the date
that
of
order,
approval.
manner. You lordship is referring that after the dismissal of the order, manner revision on 4/12/2023 the revision dismissed.
Yes.
After that, my lord, for 3 months I have waited. They have not released my vehicle, man.
हमें तो गवर्नमेंट कॉपी हायर करी ताको कंप्लाई करी इट्स
Government takes its time.
प्रोसीडियर आपण केमती कहि परबे जे हमें सड़क जीव सड़क
3 months, 1 year. For the last 1 year. For the last 1 year, I am
absolutely wrong.
23/6, my lord.
We have not taken 1 year.
Yes.
The order has been passed on.
Now what happened to this 420?
420, my lord, keeping to tomorrow, my lord. For that reason, this LMC was filed on 18 and mentioned before your lordship for listing today, my lord.
KRLP is being heard by
Justice Nursing.
File is 16/4/2024.
Yes.
Okay, you satisfy me on merits. I'll just adjourn it to another day. You tell me. Tell me.
You'll also be kindly taken up tomorrow.
Tomorrow? Tomorrow will be a reference and all. Reference and all next week.
But the question is, well, the problem is that the statutory provision is there.
No. Tomorrow, why tomorrow? Tomorrow, because of that matter is there.
Yes, because of that.
You simply say that it is listed. I'll record it part here. Matter is part here.
You'll also be heard in part.
Heard in part, list on that. You satisfied?
Tomorrow, my lord, my list.
Tomorrow, let it be tomorrow, no problem. Let it be tomorrow.
The
Yes.
operation of the order only.
No, tomorrow for list to the operation.
Tomorrow?
Tomorrow to list.
Set yesterday tomorrow is set time problem.
For that reason, my lord,
That case only says that seek instruction whether you are releasing or not. You say that I have challenged it. That is infractious now. That order is that proceeding is infractious because you have challenged the main order. That is infractious.
Like the question was whether a stay has been granted or not. That is the question put by the minor.
I'm sorry, my lord. I'm interested. My lord, while I am granting that matter, my lord,
yeah, all know, my lord.
directed that instead of my lord, until unless any stay order is there, I'm not going through. That is the problem, my lord. That is. The lordship may give us.
My lord, your lordship may keep it to tomorrow, my lord.
Tomorrow.
First case, your lordship may
keep it to Monday. Your lordship.
No, your lordship may, no, my lord.
Protection.
No, I am not ignorant, my lord.
Submit before
Tomorrow you come with.
Tomorrow, yes, ma'am. Tomorrow.
Tomorrow.
Your lordship may first
Your
case.
lordship may keep that. I request to
No, no.
case, your lordship. As a
Let
first
it be,
case.
huh? Yeah,
Yes.
first. No problem.
Yes, ma'am.
No problem. Come with the judgment.
Yes, your lordship. We will tell fairly.
There was another judgment.
Your lordship has already
Yes.
also.
Where is that judgment?
If compensation proceeding is there, court has no bar to release the vehicle.
Where is that judgment?
Well, I will
It's my
apply
own judgment.
Yes, your lordship has passed, but I have searched for, they have not served a copy.
Okay,
madam.
that is, I have passed the judgment.
Yes, madam. Your lordship has passed.
There is no legal bar.
Legal bar.
No.
You search that judgment out. Tomorrow. I'll just come. Tomorrow, Mr. Maharaj, tomorrow is first
Yes,
item.
your lordship. Okay.
First item. Okay.
That there was an allegation that the 50 kg of ganja has been seized.
The merit you have provided no cases. Merit con other case nine. Case this application is itself not maintainable.
Achha.
How it is not maintainable?
High Court case file release. Direct file the application to release the vehicle.
Yes.
Before this on.
Yes. Sir, in case of Ghasna Mahapatra versus State of Orissa, where I've dealt with this case, similar matter where this Honorable Court also directed for the release of the vehicle.
But you have to go to the court of first instance. You can't come straight away here.
Trial court.
You have filed nothing and you straight away you filed here. Then counsel the petitioner seeks
May I request
seeks to withdraw this petition with the liberty to approach the court below under section 457 CRPG for release of the vehicle. With this liberty, the petitioner is disposed of.
26.
Nama Ghasna Mahapatra.
May I please, your lordship? On behalf of P. Hon'Ble, your lordship. Lordship, this is the compromise matter and I annex the compromise affidavit on annex of 4 lordship. No, it's a power file con and opposite 22 number.
I'm appearing on behalf of opposite party number 2.
You give the wakalat now or bring the party?
Yes.
Another matter, the opposite party number 2 is the petitioner in another matter.
Where is that?
That is CRLMC number 1422 of 2020.
When that matter is coming up?
Fresh
matter?
Yes, madam.
List both the matters. Whenever
Next week.
next week will be
Parting yes.
Okay. Yes.
27.
Hmm.
9/7/2013 and the NBW has been issued on 9/7/2013 on bail.
NBW 6/6/2016
2016 lordship.
6/6/2016 1000
Two petitions there lordship.
1000 each
500 each.
500 each, yeah.
28.
28 minute question of individual Miller.
Yeah.
28 minute question of individual dated Miller.
NBW dated 30/1/24.
Again.
Bail.
And earlier was it was 30/6/2017.
Yes, Miller.
ठीक है 1000 500 yes
29.
Example, bail on 10/12/2018 Mallard and 9/1/2024 is NBW.
500
30.
On behalf of Mr. Khotwal lordship. NBW has been issued on 22/4/2022. The petition was on bail on 3/10/2013.
3/10/2013
on bail.
and NBW
22/4/2022 lordship.
22/4/2022 Please, prayer, what are you writing? Prayer, you are writing 12/4/2022. That's the problem, and these people will look at this and write and move application.
But
Huh?
Sorry, Lordship, 12/4/2022, rightly.
You be sure about what you are.
12/4/2022.
ବାର ଚାରି ନା?
12/4.
12/4 ଲେଖିଛନ୍ତି 22/4 କହୁଛନ୍ତି।
Mr. Khotto has reflected as 22/4 for that reason. I have sorry.
It is
12/4
12/4/22.
12/4 22 500 है। ठीक है next
31.
31 also Belgium matter, Lordship, enclosed in 16/5/2013, Lordship.
16/5/2013
Yes.
NBW and bail
Bail 3/6/2013, Lordship.
300 1000 1000 yes
32.
32 my lord. Bail on 16/9/2009 NBW 17/10/2017 my lord.
16/9/2009
No re bail.
bail
17/10/2017 NBW.
1000
33.
My lord, bail on 28/2/24 my lord and 13/3/24 my lord.
देखो तो 24
My lord. 13/3/24.
34.
34 my lord, bail jump was 15/9/2023 and released on bail on 30/9/2022.
500
All are before my lord.
30th of May
30th, some more time.
30th May standard time
You within 1 week copy variable time like some Saturday Sunday we so at least my lord.
May 30th
Oh like sorry.
35.
Belgium matter my lord, bail my lord 26/9/2022, NBW issued my lord 15/3/2024 my lord.
Right.
500
36.
yes just see Mr. Rahul bail bail on 5/8/19 and NBW on
27
July
23.
500
Yes, my lord.
yes
37.
May I please, Lordship? My lord, NBW issued on 7/3/2024 my lord. And bail on 16/8/19.
bail and
16
NBW
to 19.
7/3/24
Yes.
how many of you are there 500 each
My lord, last month my lord.
but so many people are there
So many people, my lord.
5
5% my lord. Last month NBW was issued one date where they are
1000 in total
total.
one
Okay.
huh? all 5 will be 1000 in total
1000 total.
for all 5
Obliged.
okay
38.
This will not similar date of NBW 30/10/2018 he was on bail my lord 20/1/2015 your lordship 20/1/2015 who was on bail NBW my lord 30/10/2018
Yes.
1000 yes
obliged
39.
39 my lord. Effect remove within a week lordship. Okay. My lord.
you already next yes
40.
May I please, Your Lordship?
Today we removed the defect. The fact is that the matter is amicable settled between the parties and they file it for passing of the inter criminal proceeding. Your lordship kindly keep it for next week.
settlement huh?
First,
okay.
on Tuesday.
bring them
Yes. Obliged.
41.
yes 41 nothing is filed nothing is filed only FIR is lodged and proceed addition कर दो August में करो by the time you file charge sheet
42.
what is this cognizance order charge sheet filed huh? FIR 419 304B What is wrong in count? Adjourn.
43.
My please, there is some defects for removal, my lord, 2 weeks time may be given.
It's time to cure the defects.
44.
Mr. Jugal Kureshwar Pandya Lordship, kindly permit to withdraw, Lordship.
Withdraw.
45.
Memo दीजिए withdraw. Please give them.
45.
Hey, हमरो कोड पे 45. What is the judge for? Why the this is not reflecting? 44 देखो.
नहीं 45 नहीं.
नहीं
45.
अभी देखिए ना 45.
अब से दो अपलोड होता है. 45.
What is this 45?
45 टा देखो. 45 yes.
45.
45 withdrawal file already.
हाँ तो 45.
45 पे withdraw.
हाँ memo file. 44 भी file. 44 भी withdraw.
Withdraw memo to be
Memo file to be.
46.
Forty-six.
45 টা my lord, 45 টা withdraw.
Memo file.
Forty-six.
46. See, in 46 or 19 to 2024, I have said no further adjournment will be given, interim order continues. Thereafter, on 26 February, again time was sought. अच्छा mediation center.
Mediation center.
Mediation report actually देखो. Mediation report. Mediation report आ गया ना. Settle.
The private party. Counsel for the petition of Jitendra Kumar Mishra or the opposite party?
Mediation to 20 percent. Six 5/2024 now it is please. ठीक है. The awaiting mediation report. Adjourned.
Yes.
47.
My lord.
What is it? Charge sheet, what is the position? Charge sheet?
No, my lord, no charge sheet has been filed, my lord.
Last time it was adjourned.
Yes, my lord.
Awaiting the charge sheet.
Your lordship was directed for submit the charge sheet, my lord, in last occasion.
Charge sheet has not been filed.
No, my lord.
No, not filing this court copy of charge sheet or really charge sheet is not filed.
Instruction, I will take instruction, my lord.
Mr. Rahul appearing for the state seek further time to get instruction for release the matter. Yes.
48.
Lordship, item number 48, there is a defect of ₹1 rupee in postal stamp. So it will be removed today and release this matter after a week. Obliged.
49.
My lordship, last time the notice has been served to the opposite party number 2. And I have inquired her present address. She is residing in hostel, one of the hostel. So kindly give a time that I will file present address, my lordship.
Then counsel for the petitioners seeks permission of the court to place on permission of file press addresses of the party number 2. Let the petitioner file the press address. Notice be served on opposite party number 2 in the press address. Yes, at the end.
Next.
Item 50.
50, may I please, Your Lordship, on behalf of Mr. Manti, Lordship, there a modification need to happen. I have made a chart for that modification.
Modification of what?
Modification of paragraph number 3, Your Lordship.
The order dated 9/4.
9/4/2020.
What is paragraph 3? What is wrong?
Lordship, but there was two NBW. One is NBW dated 24 April 2023, issued against the present petitioner number 1, and NBW dated 24 May 2023, issued against petitioner number 2 to 5.
You should have filed 2 different petitions. How can you club together all NBWs? That is the reason this problem.
2 NBWs here.
2 NBWs issued against 2 different accused. You should have filed 2 different petitions.
Lordship, order was one order. That's why. I have made a chart for that modification.
That day, why you have not pointed out?
That day, I was not.
You are unnecessary increasing work. Give the chart. And it paragraph for you. Petition number 1 was granted bail on such and such, and petition number 2 and 3 were granted bail on such and such. However, they did not appear, no?
Yes.
However, they did not appear before the court below on 24 April
2023. 23 and 24.
Bail order
2000.
is 9/4/2024, right? ठीक तो लिखा है 24 on different dates you got the bail.
Yes, bail dates are different and NBW dates are also different. One is of 24 April 2023 and another is
What
of
are you talking about? See, NBW issued all dates are same.
Let's say April and May is there.
Okay, 1 April. Para 3 है ना? Para 3 जो लिखा है कि petitioner number 1 was granted bail on such and such day. हाँ, तब ठीक करो. ठीक है, ठीक करो. और NBW भी ठीक है. Okay. Allowed.
51.
My lord. All these batch of cases. My lord, all these batch of cases, different CLMC cases are related to degener of check matter. Proceeding under section 138 of an act.
You are accused.
Yes, my lord.
Yes.
And I am the petitioner, and as per the direction of the honorable court, we have we went to mediation center, and mediation is successful, my lord. Yes. Matter has been settled and all the money has been paid also.
Where is that?
My lord, kindly see.
Opposite party. Who is appearing for opposite party? You got it?
My lord, I have got it.
Huh?
Only in another case, I have got only the principal part, but I have not got the, but that is not before your lordship today.
Huh?
That is not before your lordship today.
Okay. All these matters are now settled.
May I pray your lordship?
What is the directed proposal? Right on. Right on. Why the order? The same order in all the matters?
In all the matters. May I pay your lordship? Another matter, CRLMC 1138 of 2013 of this same general matter. That is pending. May I?
That will be listed tomorrow.
My lord,
Might be listed tomorrow.
That will be. Okay. No, what I'm asking is, in all the cases, the direction for mediation is the same day.
Yes, ma'am.
Different days.
On the same day.
Same day.
Yes.
1 minute. Right. Why the order dated
kindly see this.
22/9/2023.
15.
This court has relegated the parties to the mediation High Court Mediation Center for exploring the possibility of mediation. The parties have the petitioner and opposite parties have participated in the mediation, and the mediation came out to be successful. The High Court of Orissa Mediation Center, its mediation report dated 15/12/2023, have intimated this court regarding the successful mediation. The mediation report is taken on record. Then comes for the opposite party submits that pursuant to the mediation, the entire check amount has already been received by him. Therefore, he doesn't have any grievance. In view of the claim, he submits that this court can give indemnification petitioner and was the criminal prosecution launched by him against the petitioners. The next program, the mediation report dated 15/12/2023 may be treated as part of this judgment. May be treated as part of this judgment, and the parties are directed to strictly comply with terms of the mediation, terms of the settlement, in view of the aforementioned. Sabu case alga alga kyo ICC case number alga alga na ICC case number alga alga kyo cost.
Let another matter 113 CLMC 1139 of 2012. Nothing was used, so that may be cost also. It may be listed.
Matter is listed.
It may be listed now. It is not.
Tomorrow you give the
Yes, madam.
11/38/2013.
whatever
39.
all the 1, 2, 4, 5, 4
One,
matters.
38
All the
of-
4 matters disposed of. Yes. The two
Obliged matter.
yes, sir.
May I please, my lords.
Yes, sir.
In this case, petitioner below challenges annexed to the cognizance order below dated 9/2/2018. My lords may kindly look at page 58 below.
58.
58.
58.
My lords, high weight.
Yes.
Plus, order dated 9/2/2018. Advance PR order section 92 of Factories Act received from the Assistant Director of Factories, Boiler,
58,
Jajpur.
where are you reading? Which
I am placing below cognizance order below.
dated?
9/2/2018.
9/2/2018, my lords.
That is at the page number
58. High weight. Annexed to 2, my lords.
58 is 9/2/2018.
My lords.
That is at 56.
My lords.
Yes.
Plus, advance PR under section 92 Factories Act is received from Assistant Director of Factories and Boiler, Jajpur Road, is registered. Peruse the case record. There is prima facie case against the accused persons, namely K. Srinivasan, Managing Director, and Ranji Varghese, Unit Head, Business Carbon and Universal Limited, at so-and-so, post so-and-so, district so-and-so. Cognizance of offence under section 92 of Factories Act taken, issue summons to the accused persons. Plus, my first and foremost submission before Lordship is this complaint petition, which your Lordship will find from Annexure 1.
Yes.
That is lost on 4/10/2017. My Lords may kindly see Annexure 1.
Yes.
It starts from page 40.
Yes.
My Lords may kindly see at the top, date of occurrence is 25/6/2017.
Yes.
My Lords. And at the last second page, your Lordship will find the date of complaint petition 4/10/2017. That is more than 3 months later.
No,
My
no.
Lords,
25/6/2017 is the date of occurrence.
date of occurrence, and the complaint petition is filed by Assistant Director on 4/10/2017.
4/10/2017.
My Lords. Now I will take your Lordship's attention to that is specific cognizance provision under the Factories Act, my Lords. Section 105.
I have also quoted in the petition itself.
Where is that?
Okay.
Petition you reported.
Page 28.
20, 20.
105 picture. 105 budget put him. Not sure. 105 is at page 22 minors. First 105 years. There is specific provision for cognizance of offense under the Factories Act.
Provision?
Page 22.
Page 22 minors.
No, wait, I got.
Again.
105.
Page?
No.
Section?
Section 105. 105.
Yes.
Yes, sir. Subsection 1. No court shall take cognizance of any offense under this act except on complaint by or with the previous sanction in writing of an inspector.
Sanction.
And subsection 2. No court below that of a presidential magistrate or magistrate of first class shall try any offense punishable under this act. Now, my lords may kindly see 106. That is what I will refer to. Limitation, yes. No court shall take cognizance of any offense punishable under this act unless complaint thereof is made within 3 months of the date on which the alleged commission of offense came to the knowledge of an inspector. Yes, let me stop here because the proviso is not applicable here. So now your lordship may kindly come back to the complaint petition.
Where is do they say anything about knowledge?
Yes, exactly. That, milords, your lordship may kindly see. That is at page 40, my lords. Problem. Page 45 is relevant, milords. I'm sorry. Annexure 1, page 45, milords.
Yes.
This is an investigation report of the accident, milords, which is submitted along with the complaint application, because the investigation report is also dated 4/10/2017, which your lordship will find at the fag end of the report, milords.
Right.
My lords. Now, my lords may kindly see, milords, column number 7.
Column 7.
That is at page 45, column number 7. Date and time of receipt of information and notice of accident.
Page 40, column number 7.
Column number 7, my lords. Date and time of receipt of information, notice of accident. Now you also can see right hand side column.
43.
43. Sorry, my lords.
Date and time, yes.
Yes, my lords.
Telephonic.
Telephonic, yes.
By the management on
25/6/2017 and form number 18 received on 27/6/2017. So both the dates are dates indicating the knowledge of the milords, the informant milords, the complainant. Now your lordship kindly see form 18 is also annexed here. That your lordship will find.
I understood. Knowledge is also, if you take
Exactly,
knowledge of the date, then also it is beyond 3
Correct.
months.
Yeah,
And occurrence has 3 months.
Correct.
How will you get over 106?
There are
That
two
judgment
cases,
also.
two cases, my lord. My lord, the sub-item is there, my lord. So, you know,
Similar prayer.
much similar prayer, my lord. But what happened in this case, my lord, on 15/3/2024, my lord, the matter was listed before the coordinated bench, my lord. There, this additional standing counsel sought for instruction, my lord. But I have not come and can taken up next week. I will attend this. Only my
Why have you allowed them to argue for the
Face of it is there.
Yeah, face of it. It's a matter of record. I don't think.
How will you get over 106?
since my friend has
What
been
instruction?
already
See,
checklist.
whatever instruction you get, that will not beyond the record.
Two things are there, my lord. Whether the will count the knowledge, my lord. When the
Knowledge
form
of the use a telephonic message you got.
whether the telephone message is calculated or
Yes.
from the form number 8, my lord.
No,
You calculate in from both, it is
Correct.
3.
Correct. 18 also.
15 date is 15 June and 17 June.
My lord, sub item,
You take 17 June.
when the
Okay,
sub item,
17 June.
my lord, this sub item, my lord, my lord, that is the, my lord, the form number 18 is received on 7th, my lord. My lord, that is within 90 days, my lord.
No.
Sub item, my lord.
For itself on the complaint petition, he says, I have received telephonic message on such and such date.
What are the offences?
92.
92. Again, you know,
Come to the main point.
Exactly.
What is
now my lordship may kindly section 92. Let me place it before lordship. That is your lordship rightly asked. Section 92.
What is the penalty?
No. 92 says that this is to be directed against the miller's occupier or manager of the factory. And here the petition for lordship millers, the accused persons,
Recently, I passed an order. Same.
neither occupier nor manager millers.
Recently, I think.
Here I am.
92 doesn't apply.
I am a managing director.
Criminal revision matter.
I passed it.
In the criminal revision matter,
Ah.
and the commission under section 92
I-
Factory Act, lordship.
I said about
My factory in Chennai,
Revision.
I am a supplier, neither I am manager nor occupier. How can 92 apply? On the face of it.
What is the incident?
Millers, incident is,
How many people got injured?
no, Miller one died.
In my case, one died.
Ah.
We have paid him compensation.
How
That
much? How much you have paid?
15 lakhs we have paid.
It is there on record.
Yes, I have given the receipt, etc. So everything.
In my case, Millers, I am a supplier, Millers. I have supplied corrosive Millers catalyst in 2011, Millers. And in
I'll quash it. Get ready to pay heavy cost. Everything. You have to pay something to the bar, something to the victim. I'll quash it.
bar, it's okay, your lordship.
And victim also pay something.
But on the face of it,
50 minutes I have paid 15 lakhs. I have given receipt, etc.
I'm putting it to when.
Third matter. Next week, third.
In the meantime, it will take just 2
I have
minutes.
given copies of the decision reference to
order sheet will say how many times. I'm sorry to say.
Yes,
Stage operating.
No, councils are changing, so I don't
The
blame
matter
you.
was partly heard.
We are not blaming, yes.
The matter was
Yes.
partly heard.
Yes.
At this stage, Mr. Ragada seeks further time to get instruction. Release the matter on 3rd. It is made clear that no further adjournment.
Oblige, Millers.
Small matter, why? And let the bar earn something and.
That's right. That your lordship is direct.
And
Let
the
somebody be
victim
paid.
also get something.
Victim, we have paid your lordship direct in my case.
Some token.
Give something to the bar, we will be glad.
We'll pass it. Yes,
We'll
sir.
be glad.
Yes.
ସେଟା compromise ଟା ଆଜ୍ଞା ଦେଇଛୁ 1/6 ପଟେ ଆଣିକି ଦେଇ ସାରିଣି ସେ ଯୋଉ 16
ମହାରାଜ ବାବୁ କହିଲେ କରିଦବା। କୋଉଟା item କହିଲେ?
16. Item 16. 1/6.
I'm sorry, Millers, entry mode to
Entry mode to cut.
Both the cases.
Both. Yes. 16 the code ହଉଛି। 16 ନା? Yes. ଦେଖିଲେ ତ ଆପଣ?
Consensual relationship.
Right up. Who is the informant? Father.
Father is the informant.
Number 2.
Damodar Sahu,
Damodar Sahu. At the instance of opposite party number 2, FIR number so and so under section so and so came to be reached against the petitioner. The petitioner. After investigation, charge sheet been filed on. A charge sheet is filed on.
charge sheet filed on also 8/10/2018.
This case matter, is something is.
Hmm.
I will tell you.
Hmm.
She has not married the accused.
Okay.
She had married to some other person, your lordship. They had construction relationship, your lordship, fade away. And the later stage, your lordship, due to disagree of the parents, they
What was
married
her age when this?
22 year lordship.
Now.
By that time 16 ବର୍ଷ 3 ମାସ
16 years.
25 ଦିନ।
ଆମ ଗାଁରେ ଗୋଟେ ମିକ୍ସଚର ଫ୍ୟାକ୍ଟ୍ରି ଅଛି ସେଠି ଏବେ ପରିଘର କାମ କରିବାକୁ
I think important in respect of the accused.
ସରେ ଆମେ ଏଇଦିନ
Somehow or other, we can alternative motive come up and therefore proceed. Automatically.
ଝିଅର societal relationship ଟା ଖରାପ ହବ ସେଥିପାଇଁ ପଶି ଝିଅ କହୁନି ଯେ ତା ବାହା ହେଲେ ତା ଶ୍ୱଶୁର ଜାଣିଲେ ତାକୁ ରଖିବେ। ତମ ଜଜମେଣ୍ଟ ତ ସାରଙ୍କର ସେଇଆ ଆଉ societal relationship ଆଉ
She has married to someone else. Ask whether her marital life will be disturbed because of his pregnancy. Yes, she is given consent. She is gone. Who is accused? Who is accused?
The
Where is
accused is
accused?
here.
Hariyara?
Hariyara. He's here.
That's the reality. The moment they'll come to know about this case, her present marital life will be spoiled. And whatever has happened, what to do? Name on 21/2/2024, the matter was relegated to the Orissa High Court, District Mediation Center, Baleshwar District Mediation Center, for exploring the possibility of settlement. Exclude the possibility of settlement. The parties have, where is the mediation report? Mediation report. Mediation report. Yes, is there. Parties have successfully arrived at a settlement. Arrived at a settlement. The district mediation center is Baleshwar. District Legal Services Authority Baleshwar. While the report dated 21/3/2020 settlement regarding the settlement. The where is the regarding the terms of settlement dated 21/3/2018 since the mediation is successful and a report has been placed in the record. There is no legal impediment is possibly required and constitutional Yes.
54 May.
Yes.
54 my lord. I'm challenging the cognizance taken by Learned JMFC ASCA by GR case number 1360 of 2020.
Yes.
Even though no offenses are made out, but the cognizance is taken by Learned JMFC. My lord, the fact
Noting is there, my lord, they have to file the additional affidavit. No additional affidavit has been filed by the counsel for the petition.
Additional affidavit, there was direction.
My lord, the noting is there, my lord. 54th.
54, but I don't have any instruction regarding filing of additional
Like
affidavit.
noting the
Noting but ମୁଁ ଦେଖିଲିନି କୌଣସି order ଏଇଟା ନା. But even if it is there in the noting, my lord, but I did not find any order regarding that to file additional affidavit.
How this noting has come? Would you like to file any additional affidavit?
Then I have to take instruction. My lordship may keep update
Yes.
that I file take
Then
instructions.
counsel citizens, please stand to comply the objection. Cure the objection. Release the matter. No, there is the same matter. Then counsel, the petitioner submits that an additional affidavit has been filed in the present case, which is not available on record. On such ground, the adjournment is sought for. Registry requested to include the affidavit. This is there
Then
in
I will
order.
take instruction and short that your lordship may fix order.
There is an order. I kindly call. The order dated 18/10/2022 has not been complied. Complied. I will not for the petitioner seeks for the time urgent. Why these proceedings are not scanned? See, this matter is pending since I tell you these proceedings are not there. 21/9/2022. Thereafter 18/10/2022. Thereafter 4/11/2022. Thereafter 14/11/2022. Thereafter 4/1/2023. Thereafter 25/1/2024. And thereafter 15/2/2024. And thereafter 14/3/2024. How many days?
No, my lord, the thing is that I'm sorry to say that I have no instruction regarding filing of additional. My lord, your lordship may short date may be given. Otherwise, lordship may, I'm ready to argue. But
8 dates.
I'm sorry, my lord. You know, lord,
You don't respect judicial time.
I'm sorry. I'm
You
extremely
not
sorry, my lord.
see some other matter would have been heard by now. You satisfy all dismiss.
My lord, you know, let me pick a short date.
No question. You satisfy me now. Otherwise I'll dismiss. 8 dates. 8 days.
Well, the fact is that I was appointed as Swechhasevi Shiksha Sahayaka and under city category, my lord.
Yes.
Then I was appointed as regular primary teacher, and all the benefits has been extended to me under city category, and I have been appointed also under city category. Thereafter, a list of candidates prepared by the DI of schools to take admission in BED, to take an BED course, where my serial number was placed in 77 to take admission in BED course. Thereafter, I was continuing my duty successfully without any flaw. Then my service book was prepared where my qualification was mentioned as BED. For a moment, your lordship may see that I have not prepared my service book. Rather, a service book prepared by the authority or the clerk. It is the clerical mistake, not my mistake, my lord. Thereafter, to delete the entry of service book, I prepared many representation, which is on 16/10/2012.
Come to the allegation.
Allegation.
Come to the charge sheet. What is the allegation?
That
See,
is
you are challenging the cognizance order.
Yes, ma'am.
Just see whether in the charge sheet whether any prima facie case is made out or not. Simple.
Though it is made,
all these facts will be verified in the trial.
My lord, your lordship may see
I
that.
have to only see the charge sheet. If prima facie case is made out, it is made out.
Your lordship, for a moment, your lordship see the page number 29, which is a file and some RTI information.
See, madam, the RTI reply, whatever documents you are there, I am not conducting a trial. Those authenticity of those documents and everything will be tested in the appropriate stage. At the cognizance stage, I can't look into some RTI reply and on that basis I quash the proceeding.
My lord, where I have not availed any benefit.
Maybe you are correct. Maybe you are 100% correct. But what can I do? See, the limitation in a cognizance stage is this. Just see the
cognizance was taken without verifying the records, my lord.
No, come to the charge sheet, page 19. Come to the charge sheet. Come to the charge sheet and see whether anything is made out.
My lord, on this report, an IIC ASCA prepared registered PS case number 720 dated to 1/2000 under section 467, 468, 471 and 420 of IPC. And directed me to take up the investigation of the case. The investigation of case is completed. It is a true case under section 467, 468, 470.
First paragraph, first read first paragraph. All the educational professional caste certificate and of our teachers serving in various schools under the government. Accordingly, the Bachelor of Education degree, B.Ed, certificate of Bayaman Panda, that is a petitioner, so and so, who is serving as so and so under ASCA block, was sent for consent certificate issuing authority from Utkal University by so and so. Deputy Controller of Examination, Utkal University, by so and so has informed that B.Ed certificate detail of Mr. Panda is not tallied with the university record, hence found to be fake. This is the allegation in the charge sheet, and on that basis cognizance is taken. What is wrong in it? You are bringing RTI information, you are bringing those are the matters where you have to,
BO also
that will be
examined.
stated in the trials.
BO manner examining the one situation is clear stated that Utkal Biswada Bhunsa Patra Sankhati Janale Baya Manapandakara read
Court is not the.
My humble submission, you listened to my last submission.
Entertain the present petition at this stage. However, liberty is granted to the petitioner to raise all the point at appropriate stage before the court below. With this liberty, the petition is disposed of. Right. Next.
My lord, may I submit only one thing, my lord? This is my last submission. Last.
Yes, yes.
My lord, there are some number of judgment of Supreme Court also where I have not availed any
8
benefits.
dates you
So
have
why the
taken.
proceeding
Now you are showing the judgment.
Liberty given.
Liberty is given. No amount of judgment will help you. These are the facts.
My lord, see, my last chance may be given. This is a.
I have already passed it out. Next. Yes.
That's it, may kindly pass over the matter after lunch.
56.
It is a case under Domestic Violence Act. So I am the husband. So opinion number 2 is the wife.
Instructions I'm giving that I was directed to file the agreement copy between the bank and the petitioner. I'm filing that. Let my learned senior complete. I'll place the matter.
Have you given the copy to?
Agreement copy between the parties. My lord, the case dehorse the agreement.
You should have given little early.
My lord, it was only to satisfy your lordship. My lord, they had a case that was pleaded out.
What they make out from that?
Pursuant to the order dated 15/4/2024, the opposite party number 2 has filed the agreement dated. Agreement dated.
Agreement of date. My lord, 24/6/2011.
Which is taken on the market is the senior counsel of the time to go through the agreement and address regarding on the next hearing. Urgent and interim order continue.
My lord, if I may, my lord, they have to establish their case from the records available.
See, last order was to file the.
Yes, I was directed to comply.
You should have filed.
I'm sorry, my lord, there is.
I don't.
My lord, one more point.
I don't understand one.
My lord, I am not fighting on this. My lord, there is one more direction.
No, I am saying something else.
Your lordship.
If there is an order of the court,
Your lordship.
File something.
My lord.
How do you come with the document and throw it in the court? It should be filed.
Your
What
lordship.
is this practice? I don't understand.
I
This is
bow.
a very bad practice. If there is a direction of the court to file some document, you should file it
Your lordship.
and give advance copy. Not that you carry the copy and throw it in the court.
I bow down, your lordship. I'll keep
See,
it in mind, my lord.
This is that. Therefore, I am simply there.
My lord, that is
what do you
one.
want to say?
Yes, my lord, there was a direction. Your lordship will see that there is also noting that they are to produce the vehicle before the IIC Keonjhar and the IIC Keonjhar police station.
That you are repeating. That was reported by the.
They are produced, my lord, that is genuine.
Yes.
The truck stands in
You
the
have
name
heard
of
that.
Ashok Kumar Mishra. I also verified the registration details, insurance details found to be the name of Ashok
This is
Mishra.
the instruction you got.
My lord.
A copy of instruction.
Copy, my lord.
Are you placing that on record?
My lord,
Today you are.
My lord, just.
Perhaps you had given the last.
Ragada also received the instruction from
Keonjhar.
from IIC which
Keonjhar.
IIC sold to IIC sold to placed on record. The same is placed on record. Same is placed on record.
And also
copy of the instruction is also supplied to the counsel for the petitioner as well as opposite party number 2. Please the
How
matter.
does?
It take the copy.
Your lordship. My lord, can we have it next week?
Yes.
Subject to availability of the.
He will give.
Can we have it next week?
Yes, he will adjust and give.
As your
The
lordship.
copy of the agreement he had to file today, my lord, may be given.
I'll give one copy to my.
You please give. Otherwise,
give-
again it will be.
No, my lord, I'll do that.
The lordship interim order content.
Interim order.
58.
May I please? A petitioner are charge sheeted under section 364A with other allied offences. The dispute is the transaction of credit bill. Metal small business, 25,000 ଜାଗାରେ 14,000 ଜଣଙ୍କୁ ଦେଇକିରି ଉଠେଇ ଦେଇଥିଲେ, out of court settle ହେଇଯାଇଛି. The matter.
Settle.
Yes, ma'am.
The persons are there, my lord. The victim is present. The petitioner is also present.
This case. The other case, no? Other case, take on.
I have annexed the charge sheet, copy of the charge sheet.
Mr. Nagoda?
That has been.
Settlement. What is the case?
Kindly have a glance to page 23 of my petition, my lord. During course of it, may I read?
Yeah, during the course of investigation, you know, first paragraph. What is your name? Your name is?
My lord, with the petitioners are there, but the informant is Sukor Raut, mother of the victim person.
How many? Santosh Mahanti,
Yes.
Pullu, Bhavani.
Santosh Mahanti, Jyotiranjan Mahanti, and Bhavani Sankar Pan.
Opposite party number 2 is there. You are not included.
But notice has gone.
How notice has gone? There is no
They
opposite party.
they appeared, my lord. They appeared somewhere.
Where?
No, Okalana Pradeep Parida.
There is no opposite party.
No,
You are not included.
Pradeep Parida appear करचन.
Huh?
List में देख ले Pradeep Parida का नाम.
Okay, name is there.
Name is there. Informant.
If he is not party, how can you file a wakalatnama? You have to make the opposite party.
Regular
You have to
Include here. As you, if your lordship direct me, I can include.
File wakalatnama. You are appearing for opposite party.
Yes.
You file wakalatnama.
Yes, my lord. Is associated with Mr. Pradeep Kumar Parida.
But how wakalatnama is taken on record if he is not a party for whom he has appeared?
Probably the first order, in the first order, probably he implicated the party. I have not gone.
Where is that? Just Jyoti just see.
The first order, January 2002.
And you have wasted 3-4 hearing unnecessary.
Yes, your lordship may fix another date. I am implementing your lordship. As per your direction, I am implementing him as a party.
No, the order is 11/1/2023. Notice is in a implemented order. No. Without implemented, how is it? What is this going on? I don't know. And the order of 11th January 2023 is notice be issued to the informant.
Yes, my lord. On that order,
informant is not a party. Court might have asked you to implement and you have not implemented.
They have not implemented.
By mistake, it is also.
Not by mistake. 2023 January it is pending. Then comes for the petitioner seeks to implement the informant of the case as opposite party number 2. He may do so during the course of the day countersigned. Release it Monday, Tuesday. Let the party come. Let the party come. Monday, Tuesday, let us again.
My lord, may I pray? My lord, the informant is old age lady. The victim is the son of the informant. And he may present.
Informant, what is the age of informant?
60, about 60 years.
60 is
and
not
I was suffering from asthma and as your lordship directly.
the settlement, the informant has to come, not that
Yes,
somebody
yes.
else has taken the
Yes,
money
my lord.
and, coming to the court and
Yes, my lord.
that list
Along with the
is
informant.
there. Yes. On the ground of settlement, if you want classmate, at least the necessary parties
Yes, my
will be
lord.
there in the court. Yes. Next.
59.
On Monday, my lord.
You'll give date. Yes.
Yes, my lord. Now, my lord, there's a very limited issue in this case, my lord. There are only 2 issues, my lord. Whether there can be.
Why this matter is pending since 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 hearings.
My lord, yeah, initially, my lord, it will not come before the board, and sometime, my lord, it got transferred from one court to another court.
Last occasion, my lord, Mr. Mishra, Mr. Senior Advocate.
Last, of course, Mr. Mishra
My
had some
friend is
personal
giving
difficulty.
emphasis upon one adjournment I took.
No,
Not about the other
I'm not,
days.
my lord, I'm not saying
Anyway, what is
anybody
this
anything.
case? That was the only time
My
I
lord,
took
there's a
time. What is
limited
this
issue,
case?
my lord, limited issue is whether there
Yes.
can be second FIR on the same set of incident or connected to same set of incident. And the second is whether the magistrate who has taken cognizance of this complaint under section 200 ought to have taken this into account before taking cognizance, my lord. So non-application of mind is apparent on face of it, my lord. So there is several judgments to this, my lord. But before, my lord, I'll draw your attention to page 36 of this, my petition, my lord. The cognizance order, and 37 is the summon. Now, my lord, 36, my lord, running page number 36 of my petition, my lord.
46, huh?
36.
36.
Yes, my lord.
Yes, 36.
You know, my lord, may see 13/9/2022.
Yes.
The cognizance order, my lord. The
Yes.
case record is put up today for accordance of necessary order in respect of cognizance, heard, peruse the complaint, petition, so and so, my lord, under section 200 and other available materials, record found that a prima facie case punishable for the offense under section 408, 465, 468, 469, 471, 201 of IPC and 66, 66D.
Yes.
And
Yes.
so this is the, my lord, offense against me in this case, my lord.
Right.
Now, my lord, what the non-application of mind is apparent on face of it, my lord. I'll demonstrate.
You are challenging this order.
Cognizance order, my lord, and summon thereafter.
Show me 200 statement if anything is made out. It's all right.
No, my lord, there's something more, my lord. My lord, may just bear with me for 5 minutes, my lord. My lord, may see there are two FIRs. The first FIR, where I was called, investigated for 3 days, and my name was put in the list of witnesses. Now, that was, my lord, in police station Jatni. That the FIR was drawn on 8/1/2021. The charge sheet was filed on 24/3/2021. The moment, my lord, the complainant, which is a university there, my lord, I was a CEO, chief executive officer, my lord, there. The moment they realized that I have not been, they failed to implicate me in that case, my lord. They have filed the same FIR against in Gurendi police station, bringing some additional irrelevant facts, my lord, trying to show a color of a new complaint. My lord, that is something the magistrate ought to have taken into consideration before issuing summon to me and taking cognizance, issuing summon to me. That's my case, my lord. My lord may see.
Cognizance is taken in the second complaint.
No, my lord. What happened? First FIR, my name was, I became witness. Second FIR, the IO has investigated and drawn a closer report.
Thereafter, he filed protest petition, 200 statement is recorded and cognizance is taken.
And everything is same. So, my lord may see how it has been done. My lord, it will take 5 minutes. My lord may see
Take me to the protest petition and 200 statement. If anything is made out, then cognizance is rightly taken. If nothing is made out, then some other remedy.
No, my lord.
Show me the complaint.
My lord, first, my lord, no, my lord. What I'm saying is, if my lord, the FIR has been drawn and my name is not there, then whether the magistrate was right in taking this decision without ignoring this fact that the law is that there cannot be second FIR. Now, my lord, that is one aspect. My lord, bear with me 5 minutes, my lord. Just 5 minutes.
Yes. Show me whatever you want to show.
Yes, my lord. Running page number 98, the first complaint, my lord.
98.
Yeah, running page 98.
Yes.
No, my lord, it is the complaint that was drawn by the university against the chief financial officer, CFO. Now, my lord, may see, I, Chitranjan Patnaik, aged of so and so, senior manager so-and-so do hereby inform that Chief Financial Officer Sri Himanshu Sekhar Kabi, in connivance with Sri Ventures and Sai Sano Enterprises, has misappropriated an amount of 84 lakhs by tampering into the official document, preparing forged documents, fraudulently raising demand for payment, suppressing material facts, using and abusing his official position and powers, effected fraudulent transaction in 8 different occasions through bank account of CI, that is Centurion University Trust, held in ICICI Bank Jatni branch, and account number held with the State Bank of India Jatni branch. So 2 branch of, my lord, that university, and this CFO is under litigation to this. Now, my lord, next para, my lord. Being the chief financial officer, his job is to pass the bills, vouchers, invoices, demand for official payment as the checkers as to its necessity, correctness, and accuracy. Backed by the knowledge of CEO Sri Vineet Chatwal, the process of, my lord, here is one sentence against me. I am Vineet Chatwal, the petitioner before your lordship, and I am the CEO, my lord. Now, my lord, my humble submission is, may see the second para. Here, during COVID-19 pandemic, taking advantage of the non-operational of offline transaction and dependency of the organization, the online transaction, the CFO, Mr. Himanshu Kabi, has siphoned, misappropriated 57,75,398 by transferring the money to the bank account of so-and-so, Rasulgarh branch, in favor of Sri Ventures on 5 occasions, period from such and such, my lord. That is one transaction, that 5 occasions against in one case, my lord. My lord, may come to the second thing, my lord. The third para. Similarly, Mr. Kabi, by the same process of practicing fraud on 2 occasions, i.e. on 8/10/2020 and 9/12/2020, rupees 11,55,000 on each occasion, thereby, my lord, 23,000, 10,000 in total, my lord, he has committed a fraud. And similarly, my lord, on the last para, 4,10,000 also he has committed.
According to you, Kavi has done everything.
No, my lord, that is not merely this, my lord. There, my name was dragged, and I was interrogated by IO Jatni police station for 3 days, 10th, 11th, and 12th.
And I understood it. You are saying after investigation, charge sheet was filed against Kabi and all, and you are arraigned as a witness. That's what you want to say.
But there is what happened in between, my lord. Why my name? So once charge sheet was filed, the university, in wreaking vengeance against me, my lord, filed another complaint.
Mr. Singh, I understood it. Next, you tell me what is your point. I understood it.
Yes, my lord.
So I now also I understood one thing, why this matter has taken 13 hearings.
I don't know, my lord.
It doesn't require so much elaboration. You tell me what exactly
you want. I understood. The first person to hear, my lord.
See, your submission is the first FIR was investigated, charge sheet was filed, yes, you have been arraigned as a witness. Next, yes, you tell. You show me the second FIR.
No, my lord, the second FIR.
Yes.
Second FIR is on page 57.
57. Come to 57.
Yes. Now, in second FIR.
Yes, come to 57.
Page 57, my lord, may come to page 58.
Yes.
Here, my lord, second FIR, the accused is, first accused is Vineet Chatwal, second is Himanshu Sekhar Kabi.
Right.
Now,
come to 59. What are the allegations? Let us see.
59, the allegations are, the first page, my lord, is nothing, just talking about what is university, what I was.
Come to third paragraph. Mr. Vineet Chatwal
was residing so and so. My lord, it all talks about what I am, what Himanshu Sekhar Kabi was, what was my role. Basically, my lord, no allegations, my lord.
Appointed the president of university, so and so. Where is the allegation?
My lord, no, that's what I'm saying. My lord, just eyewash, my lord. They have just tried to give a color as if some new thing has come to on surface. Now, my lord, can come to the second page. Your Honor, second page on 19th December. My lord, yourself got it?
Yes, I'm there.
Second page, third para. On 19th December 2000, it came to light that Mr. Himanshu Sekhar, your Honor, got it? Himanshu Sekhar Kabi had done misappropriation of money amount to 87 lakhs, citing this. DN Raw sent an email on 20th December 2002 instructing Vinit Chatwal to seek explanation from Himanshu Kabi on this matter. And my lord, then it goes on to say why I did not take any action against him. And then he, because of my connivance, he has been able to siphon this kind of money, my lord. So
Yes,
basically,
after investigation, police now filed a closure report.
now, my lord, may see that is, my lord, something that I wanted to show, my lord. May see the closure report. My lord, I will not bother your honorship, my lord, your honor, my lord. May come to page 72, my lord.
72.
Yes, my lord.
Yes.
So the IU has investigated the case once again. My lord, may see the last para. The payment of tune of rupees 57,75,398. Your lordship got it?
Yes.
To Sri Ventures without supporting. My lord, if I take your lordship again to the first complaint, 57,75,398. This is the same amount of siphoning by Himanshu Sekhar Kabi, which is being repeated here, my lord. My lord, may come to the second page, my lord, 73, my lord.
Yes, I'm there.
Now 73, my lord, 1, 2, 3, 4, 5. Now, my lord, 5 occasions when Himanshu Sekhar Kavi, in connivance with Sri Ventures, has siphoned this money. So, my lord, the same set of incident, my lord.
Yes.
Second. Now, my lord, come to the last. Siphoning of misappropriation of funds. On the same page, funds to the trust to the tune of 23,10,000. Your honor got it?
Yes, I got it.
Now, my lord may see the same figure on the second page of the first complaint, where it says 23,10,000 with the help of Sai Sanu Enterprises. So, my lord, same set of incidents, same fraud is being investigated again. Similarly,
now come to protest petition.
No, my lord, one more thing, my lord. If your honor will come to page 76 of this closure report.
Yes.
Now, closure report says the last para, my lord. In such manner, CFO Mr. Himanshu Kavi, with assistance of other employee of the university, has misappropriated university funds amounting to rupees 1 crore so and so. So more funds have been brought in. However, the case of cause of action, Jatni PS so and so, under section 408, 420 so and so, has been registered on a written report of Sri Chittaranjan Patnaik, late Sri so and so, and the investigation is in progress. In the said case, preliminary charge sheet wide number so and so against the accused persons Sujit Ranjan, Nalin Akshay, Amit Kumar Malik, and Himanshu Sekhar Kavi have not been submitted to the Honorable Court of JMFC, Jatni, keeping the investigation the case opened. In this instant case has been filed on 14/4/2021 with the same cause of action, criminal misappropriation in university funds, with some additional facts of criminal breach of trust and criminal conspiracy, theft, unauthorized transfer of confidential data, as well as disappearance of evidence by dealing the data university accusing chief executive officer. In addition, but it constitutes a part of the same transaction, and hence parallel investigation of the multiple case on the same cause of action is not maintainable in the eye of law in view of the judgment of Honorable, my lord, that famous, my lord, Anurag Goswami case, my lord. And therefore, my lord, in the next page, he says it's a mistake of law, and he files this closure report before the magistrate, my lord. The magistrate who has taken cognizance. Now, my lord, may come to the cognizance, my lord. The complaint, my lord. My lord, my humble submission is, the complaint is at page 27, which I have. Your honor, got it?
Yes, I have already read it.
You have already read it.
Now come to 200.
But that's what, my lord, complaint and the page 27.
Come to page 38.
Page
38.
29, 30, 29, my lord, page 30 is somewhere missing. My lord, page 30. 20, my lord, the brief facts of the case, my lord. that humble petition under
Yes,
section
I
under.
understood, you know, I understood. Yes.
No, my lord, my lord,
who is appealing?
my lord may
I'm-
also see, my lord, may I have a small request, my lord.
Yeah.
May also
See, I
see
understood it. See the entire transaction. Who you are appearing for?
I am appearing for the protest petition, the complainant who was the informant. My lord,
But you tell me one thing. What I gathered is from here is the entire transaction has taken place between 1/1/2020 to 19/12/2020. There were some money siphoned by these people, Kabi and this accused and all. First FIR was registered. In the first FIR, the transaction is same between this 1/1/20 to 19/12/20. FIR was investigated, and this petitioner was arraigned as a witness, being the CEO of the
that
organization.
witness he has to show. Right?
1 minute.
Document that
What I understood, clarify this. And thereafter, pertaining to the same transaction within that period, again another FIR was registered against this gentleman. It was investigated and a final charge sheet was filed. And thereafter, you file a protest petition. In the protest petition, the allegations are more or less same, except narration of his details when he was appointed, blah blah, all these things. That is not relevant for the purpose of the offense. And the 200 statement is just narration, the same fact narrated. The protest petition and the 200 statements are verbatim same. On that basis, cognizance is taken. He is agreed. Now you.
Now let me just explain.
Yes.
I will just make one distinction.
Yes.
So far as the cognizance is concerned, cognizance is of the offense, not of the person.
Yes.
The process is issued against the person. The person who is against whom the process is issued will have a grievance with regard to the process issued.
Right.
If he demonstrates in law that prima facie a process should not have been issued against him.
Right.
Now, your lordship will come back, and here I will make one distinction. Now, what my understanding for the petitioner is trying to say for your lordship is, this was the allegation, and it was Kabi who was booked. So now, as a matter of vengeance, subsequently post facto the submission of the preliminary charge sheet, this case has been lodged against me. So therefore, I should not be prosecuted and the proceedings should be quashed. Now, I would like to make one distinction, that is with regard to the role. But it is not the only period of in which it has been committed. It is the role also which is relevant, for which the process is to be issued. So that part of the things is not being pointed out to your lordship. Now I get to point out one thing. Your lordship will say again, come back to page 98.
98.
So let me just humbly clarify one thing. So this is not.
Then we'll continue. We'll continue after lunch.
Yes, sir.
I may pardon my item number 66, man. I was waiting. I have some problem, man, on my knee. I have received an injury. Item number 66, man, for which I am waiting, my lord. I have some problem, man. I have received an injury on my knee. Maybe some other day.
Huh? Okay, adjourn.
Item number 66,
He'll give a date. He'll give a date. He'll adjust and give a date. He'll communicate to you. Yes.
At the same rate,
Yes, Mr. Das.
I missed this item number 47. I beg apology.
47. Whatever you are asking, we have done it.
I was not asking for. I failed to join.
So I'll record. I will record this.
No, it's not that. It's not that. My absence, if not noted, then I'm.
No, I am not noted.
I'm grateful.
No.
Grateful.
Till right now.
I may be pardoned, my lord. Item number 60 also, my sir, kindly be take it in next week. On behalf of Mr. Sahu, we have also informed to the other opposite parties. Interim order.
There is an opposition. Wait. If there is no opposition, I can understand. If there is opposition, what to do? You have obtained interim order.
Lighter when Mr. Lordship or even if there is opposition, that will not take away your lordship's discretion to grant an adjournment.
But the adjournment, obviously adjournment will be given, but his grievance is also to be heard. Opposition. And you convince your friend during lunch so that he'll not. Any.
Fix a date, my lord.
On 6.
Interim order is there.
Entry mode to continue. That is the reason you are seeking time. If entry mode would not have been there, why should you ask for time? Fix a date.
60.
60,
yeah.
60.
He will adjust because we are going with a system. That system is any mentioning? Any mentioning? No. Thank you.
Obliged.
That I have received the instruction just day before and I received it this night, my lord. But what the documents are available in the record, my lord, I am puzzled regarding the prosecution side. I am puzzled. So your lordship may kindly adjourn
71 adjourn. You are there? Let him.
Entry mode to continue.
Entry mode to continue. No. Yes.
My lord, Hon'Ble.
No, I think 13 my lord, both parties are present, my lord.
I'm in the midst of a hearing.
My lord.
Yes.
Before I will refer to few of the documents from the petition that has been filed. Before that, just let me make some distinctions so far as the two cases are concerned. Your lordship will find, so far as the second FIR which has ended in final report in a misconception by the police, I will point out how it's a misconception. The role attributed to the present petitioner in the present case and to the other person in Himanshu Kavi in the connected case, which has got nothing to do with the role played by the present petitioner, are absolutely distinct and separate. And apart from that, your lordship will see, so far as the present case is concerned, it doesn't involve 420 and 66 of the ITR, which is in the other case. So far as this case is concerned, the additional feature is involvement of offense order section 469, 20134, 66C, 66D, and 72 of the ITR. The reason for pointing out all these things was the entire submission as I find from the counsel for the petitioner is, as if he is prosecuted twice, or the transaction is same, so therefore even if in an economic offense, it's an economic offense, it is discovered, nobody else can be prosecuted if you are not prosecuted from the inception. This is what is the logic applied. Then I will show the grounds to your lordship so far as the petition is concerned. That's not tenable. Arnav Goswami case has got absolutely no application. Your lordship knows that case. That has got nothing to do with it. But he was implicated in series of transactions. Court said no, you should have one, you cannot have many. That way. So this is the case where the accused was different, and your lordship will find absolutely there was nothing against this person in the previous FIR. I'll just point out that again with the lordship's kind permission, page 98. Page 98. That is the earlier FIR, which has been made the basis to say that the subsequent FIR, or for that matter, the process petition, are all absolutely unsustainable. Here, your lordship will find from the middle para what we say.
98.
Pardon?
98. 98. Yes.
Being the chief finance officer, his job is to pass. This is copy. The allegation is against Himanshu Kavi.
98. 1 minute. Yes.
And before that, if your lordship says 96 also, the accused is Himanshu Kavi. There was never any allegation against Vineet Chotwal. And it's not a case somebody is being prosecuted for the self-crime offense twice or anything bad. If at all the court finds that both the cases are having related to a transaction connected to each other, then there will be a joint trial in terms of 220 CRPC.
Yes.
So therefore, it's not a case that because somebody else in an economic offense is discovered subsequently an FIR is lost, or for that matter, because of the final report, a protest petition is filed, which is treated as a complaint and which makes out a prima facie case. It should be.
You show me that only.
That much. Your lordship.
I need not go into the earlier.
Only
the test is on the basis of the complaint, that is protest petition, and 202 statement, whether a case is made out or not. That's the only test.
Only one more thing. One more thing I beg to point out, because it is said on behalf of the petitioner that the earlier case was there. Earlier case, first of all, page 96 said was against Himanshu Kavi only, and the entire FIR of the earlier case commencing from page 98 and ending in page 100, so that there was absolutely nothing against this petitioner, barring the fact that he was with the knowledge of the CEO, but there was no allegation against him. Now, coming back to the present FIR, which ended in final report, your lordship will kindly see. And it is said that this complaint protest petition is repetition of the FIR. But it can be just varied completely. So it can be varied completely. When a complaint petition is filed, a protest petition is filed in the shape of a complaint petition, which is treated as a complaint petition, inquiry is done, the court is prima facie satisfied, court takes cognizance. Then the process is issued to the person whom the court feels process should be issued. Now, my lord, your lordship sees page 59. The FIR which culminated in final report and post facto that the protest was filed and resulted in a complaint and cognizance has been taken. Right. Here, your lordship will kindly see. First of all, your lordship will see page 57, the offences I was pointing out is not exactly the same. Right. Then your lordship will see the attribution. Attribution commences from page 59, and if I am correct, your lordship, subpara 5. That means he is in charge. He is in charge. The transaction takes place. One important thing I beg to point out to your lordship, which is very relevant, that is, my lord, the email where he said everything has to be rooted. It has to be within my knowledge. Where all these things have been done, all the financial misfeasance, irregularities have been done with his knowledge, and he gives the email. And that email I will show your lordship was subject matter of another case where observations have been made against this petitioner. I'll point out that. I'll assist your lordship. Before that, I just beg to point out the email. That is email dated 23/1/2020. That has been mentioned. That your lordship will kindly find in my complaint petition at page 'My your lordship may kindly bear with me for a moment. Your lordship will kindly come to page 29. Page 29. Yes. This is the complaint petition. Initial statement, 202 inquiry has been done. Initial statement is in the previous page, page 28. Then the 202 inquiry and the cognizance. Here, your lordship will kindly find in the last para, also Mr. Chotwal was looking after all purchases, giving POs, and also instructed all accounts personnel not to bring any financial matter before the founder trustees. Mr. Chotwal expressly instructed all accounts personnel to report to the CFO, that's the other accused in the connected case, only through an email dated 23rd January 2020. The accused, Mr. Chotwal, was actively looking out for investor and all those things. If your lordship, I am not wasting your lordship's valuable time. If your lordship peruses the entire complaint petition, it makes out cases. There was entrustment, there has been breach of trust, and there has been other matter which makes out offense. I need not read it, wasting your lordship's valuable time. Your lordship has heard my friend for the petitioner who said about a connected case where the CBI was investigating. The gentleman Muktikant Mishra moved reasonable court. In that case, saying that his case should be quashed, but no case is made out against him. And the case was quashed. While quashing that case, your lordship will kindly see in paragraph 42, the court refers to the same email, this 23rd of January 2020, and says that these persons are involved, namely the Himanshu Kabi and this Vinit Chotwal. Your lordship may kindly see in paragraph 42 observation. First, he was one of the co-accused. He was, that accused had come, that was a separate case. First page itself, your lordship will see, first page, that was a case by the CBI. Therein he came up for quashing. That was concerning the same institution with regard to financial irregularities. What while quashing the case of Muktikant against him, in paragraph 42, observes, your lordship will see that I have marked it.
23/1/2020 also traces the submission made by the petitioner.
My lord, may peruse 5-6 lines.
The mail by CEO of
CEO is the present petitioner.
Had a very clear instruction that if they bypass the CFO, then the consequences will follow. The said email also contains instruction that no payment request should go to the founder trustee without the CFO's clearance. And the said mail is the pointer to the intention of CEO and CFO to keep the trustee so. Yes.
So
these are the observations.
This is the situation. Now, my lord, again, I beg to point out one more thing. Ballot, since I have filed a complaint in the shape of a protest petition in the shape of a complaint, inquiry has been done. I have to prima facie show whether this protest petition and the statement of recorded in 202 inquiry is making out a case or not. And I beg to humbly pray for your lordship to peruse page 29, 30, 31, 32, the complaint petition, the initial statement in page 28, and the statements that has been recorded. It clearly makes out a case. And my lord, if at all the court feels no, this case and the other case is to be tried together, then that will be done. And it is not a case, he is being prosecuted twice, and it's an economic offense. And your lordship has seen money trail, if it is discovered, then subsequent prosecution can be there. It is not a case, my lord, that a murder case where somebody else is not an accused, so he is being made accused in a different FIR. It is not like that. So therefore, the money, my lord, so far as the malfeasance is concerned, was discovered, and your lordship will see the allegations are pointed. It's not that it is not pointed. Now the police becomes an adjudicator. Your lordship sees the final report. Though I have questioned the final report in the shape of a protest petition, and your lordship sees, I have never seen, at least maybe my friend dealing with so many criminal cases might have seen, that the police citing authorities and then saying that no case is made out, so I will not proceed. Final report. That's what he says in page 76 and 77. Your lordship sees. Police 76, your lordship will see. The police cites Hon'Ble Goswami case, then says that I will not proceed. 76, your lordship. And if your lordship sees Hon'Ble Goswami case, page 76, your lordship will see last but one line. The police talks about the cause of action, part of same transaction. Part of same transaction, there has to be a joint trial. So it's not a case of double jeopardy. So this man is trying to take a technical plea just to escape from the clutches of the prosecution because he has committed offenses. Now next page the police says that same cause of action not maintainable. So therefore parallel investigation in multiple cases. This is not the case here also. Then your lordship may kindly see the ground in the petition itself. That 483. It's all right.
Grounds and everything.
Only
And
the
why under
say ground.
Yes, Mr. Maharaj.
That is in E and F.
You are appealing.
We have already filed the final report of mistake of law because of this transaction, and this is the finding of the investigating officer, not more than that. If subsequently protest petition is filed and cognizance is taken on the face of it, if these new materials came out, and you are also satisfied that yes, there are prime materials, then taking cognizance, there is no bar so far the cognizance party is concerned. As for the investigation person, this is the investigation, this has been cut down.
The protest, the final report is filed by whom?
By the second IO, my lord. By the second IO.
No,
in Borendi police station, my lord.
Is he IPS officer or?
It has been notified. I'll give that notification. I'm dealing with another case which will come up before the lordship. The police station, ordinary police station is also empowered to. There's a notification. I'll give that and assist your lordship. I had the occasion to deal with that issue. Only one point I missed. May I assist your lordship? It was pointed out to your lordship that the order is a mechanical one. So therefore it should be
twice.
But a technical piece, in my humble submission, is not permissible. Because your lordship will see the materials. So the court says, I perused the material. He may not write that so-and-so said this, so-and-so said that. So yes, exactly your lordship. So that will not be a ground of remand or reconsideration, or it will vitiate the order to be
Yes, then Mr. Maharaj, this is your submission.
Yeah.
My lord, may I?
Yes.
My lord, may I rebut very quickly, my lord? 2-3 things, my lord. My lord, while taking cognizance, the learned magistrate has to take into account the law applicable thereto at that point of time. Now, my lord, if I may just first, before that, very quickly, my lord, 2 judgments of Supreme Court. Why, how a magistrate should take cognizance?
Give me the judgment.
Yes, my lord. The judgment, my lord, first judgment my learned friend, my friend will give is Mahmood ul Rahman. Mahmood ul Rahman. My associate is there, Madam Rakhi is there.
Give me the Rahman.
Citation ta pehle se de din. नहीं नहीं मौत
Highlight that portion and give it.
Yes.
Okay, he'll highlight and that portion and give it.
Yeah, my
Yes.
lord. Now, so what it says, my lord, is the court, my lord, read it, my lord.
What is the ratio you are?
Ratio is, my lord, I'll just 2 lines ratio, my lord. The ratio is very clear. In other words, the magistrate is not to act as a post office in taking cognizance of each and every complaint filed before him.
That observation you will find in 1,000 judgments.
No, my lord, but in
But
this
you know
case,
what happens.
My lord, in this case, my lord, I'll show, my lord, how it is. Now, my lord,
How will you deal with this Muktikant Mishra's judgment of this court?
That
where
is, my
there is
lord,
an observation.
Yes,
it
yes, my
says
lord.
that your complicity is complicity of CEO and CFO is can be seen from the email.
Fair, my lord.
That
This
email is a part
my
of
lord,
part of the complaint petition.
I'll tell you, my lord, I can satisfy, my lord. First is, this is a judgment, my lord, in CBI case, where there was a complaint against the officers of university for paying bribe to GST officers. And, my lord, in that case, Muktikant Mishra and other officers were made an accused. My lord, from here the vengeance has started. I went to CBI and made a statement without meeting him. And therefore, my lord, I have not implicated anybody. Only thing that I have done is, my lord, that I have identified the voice of Muktikant Mishra. I could not have possibly said, no, I don't understand the voice of my chairman. Now, my lord, it is, if there is a complicity, and my lord may look at this email. This email is dated 23rd January 2020. Now, my lord may see their complaint. And it is very clear that I was called by the IO of Jatni police station on 9th February. So, my lord, I have given this email to the IO. IO has taken every document from me and then filed the charge sheet. I am not shying away from anything, my lord. But the issue is, my lord, there's larger issue.
Yes, any other judgment you want to show?
My lord, before judgment, my lord, I'll show one thing more. My lord, is a bigger hurdle for them. My lord may see the protest petition. Page 27.
Yes.
Now, my lord, the page 27, the name of the accused is Vineet Chadwal. Now, my lord may see what is the offense against me, the cognizance that they have taken, my lord, on page 36. The cognizance is taken on 402, 408, 465, 468, 469, 471. These are the offense committed by Himanshu Shekhar Kabi. In absence of Himanshu Shekhar Kabi, the complete, my lord, non-application of mind. How do they say that I have committed forgery? My lord may see, there is only one accused in this complaint. And I am under investigation by 2 IO. And the IO says, I'm not saying anything. But then can I be implicated of an offense in absence of Himanshu Shekhar Kabi of forgery and taking out siphoning of funds, criminal breach of trust? My lord, this is complete non-application of mind. And therefore, my lord, the Supreme Court in another judgment says, my lord, I'll just read out. My lord, just bear with me because, my lord, I work in Dubai. Now it is a case of wreaking vengeance that they said, I will teach you a lesson because you have identified my voice. Now, my lord, I'll just show, my lord. May see, my lord, my friend may give Pepsi Food Limited and another versus a special judicial magistrate. But
that will not help you. That will not help you.
No, my lord. What is being? No, my lord, may just bear with me a little bit, my lord. I'm into difficulty, my lord. Will bear with me for some time, my lord.
I think I have heard all of you sufficiently. Generally, I don't hear so much.
My lord,
I take only 5 minutes to decide this.
My lord, that I have seen, my lord. But then, my lord,
if you are at the cognizance stage, the only test is from the complaint, that is the protest petition, and the statement under section 200, whether any case is made out or not.
My lord, with
that
due
is the
respect,
only test. And
lord,
the remaining thing, you have other options at different stages.
My lord, with due respect, my lord.
Whether
can I
this
dif-
particular offense is made out or particular offense is not made
My
out,
lord.
all these things, I need not advise you what to do, you know.
Yeah, I know, my lord, but with due respect, my lord, I may differ little bit, my lord, if your lordship will permit. It is
Give me the
not.
judgment, that's what I'm saying.
That's what, my lord, I'll give the judgment. My lord, it is not merely on the basis of a statement and the complaint cognizance
Yes,
can be
which
taken.
which paragraph you want to show?
Yes, my lord. Which judgment is before your lordship?
Pepsi food.
Pepsi Food, para 28 and 29, my lord.
Yes.
I'll just read these two paras only, my lord. May bear with me. Summoning of an accused in a criminal case is a serious matter. Criminal law cannot be set into motion as a matter of course. It is not that the complainant has to bring only 2 witnesses to support his allegations in the complaint to have a criminal law set into motion. The order of magistrate summoning the accused must reflect he has applied his mind to the facts of the case and the law applicable thereto. My lord, may I pause? If this is a second FIR, and that fact, the closure report is before the magistrate cannot ignore it, my lord. And the second is the facts of the case and law applicable thereto. Now here, my lord, may see that there is only one accused. The offense that they are talking about is nothing to do with me. Saying that I have forged the document, I have siphoned the money is an offense against Himanshu Sekhar Kabhi. It is the same offense. Now, the same offense Himanshu Sekhar Kabhi could have been also there, and to associate. Now, my lord may also see another thing. My lord, let me further go ahead. He has to examine the nature of allegation made in the complaint and evidence, both oral and document in support thereof, and would be sufficient for the complaint to succeed in bringing charge home to the accused. It is not that the magistrate is silent spectator at the time of recording preliminary evidence before summoning the accused. Magistrate has to carefully scrutinize the evidence brought on record and may even himself put questions to the complainant and his witness to elicit answers.
Yes,
Now,
any
para
other
29.
judgment? Any other judgment except para 28 and 29 of Pepsi, day in day out, this judgment is read out in this court. So therefore, I need not
I'm
read.
sure, my lord. I'm sure, my lord. Now, my lord,
So you do you have any judgment beyond this?
my lord, I will.
Give all the judgments. Why are you giving installmentally? Whatever judgment you have, give me and highlight those things and see. Proposition is the same.
Fortunately, I'm getting.
My lord, proposition is the same.
Proposition is same. You
My lord.
only what the proposition is, what you say is cognizance order is not a mere order. You have to apply the mind and pass the order. And the fact which you have narrated has not been taken into consideration.
And
that's what you want to say.
Yes, my lord. And the material available on record. The material available on record is the closure report, my lord, which shows.
That's right. That's the proposition. For that you are giving judgment. I understood the proposition.
And those material has not been taken into consideration while passing the summoning order. Now, my lord,
that's what I am saying, sir. That is the proposition. Judgment is not required. No. This is the first principle.
That's now, my lord, may come to page 36 again, my lord. If 2 minutes only, my lord. Page 36, my lord. The cognizance order. It says the case record is put on today up to date for accordance of the necessary order in respect of cognizance so and so, and the statement of witness recorded under section 24 CRPC and other available material on the record, and found that a prima facie case punishable for the offense under section so and so of IPC so and so is made out against the accused person. Accused person is me alone. Now, my lord, is it possible? How offense is made out on? They will summon me in an offense.
Okay, you, then I am reserving the judgment. You give your submission, all of you.
Written
all of you
submission,
give your submission.
written submission.
Give your
Yes, my
submission.
lord. I'll give the written submission.
Only mark the note to inquiry para 11 before delivering the judgment. Para 11 is sufficient.
Car deposition car statement are expired.
Page 41 para 11.
41.
Page 41 para 11. Only to assist me, not that.
Yes.
Because we have already filed the final report. Mr.
41 of page 41, huh?
Yes. Turning page 41 para 11.
Yes. Yes. It is also come to the notice of the university and the accused beneath along with Kabhi colluded to defame the university by recording false evidences and going on to TV on so and so. Mr. Kavi used to use the data collected by him and will see also during the course of the duty of the purpose and this amount release the trust has been kept.
So section 66 is now.
My lord, I have never appeared before any TV interview. My lord, if this is what they are talking, the magistrate is duty bound to collect this TV interview. My lord, I have never appeared before any TV interview.
At the same time, there are how many judgment you want to see? It says that at the time of taking cognizance, he can't conduct a mini trial.
No, my lord, may not conduct a mini trial, but then collect the material, my lord. Satisfy itself. Otherwise, my lord, every person, my lord, I have faced, my lord, I was grilled by the IO in the first case. And then for 3 days, I had to come from outside and appear before the IO. And if I have the investigation
Have you
goes
filed
otherwise,
any written submission?
Sir?
Have you filed any written submission?
I will file, my lord. I'll file a written submission.
You please file written submission.
By Monday.
My lord, another thing, my lord may see this. In the same offense, I'll be witness also. In the same offense, I will be accused also.
There is no point repeating. I understood the.
Another, my lord, one more, if your honor will permit, one more thing. What my learned friend was saying that there can be 2 FIR and the trial can be. My lord, if a statement is given by a witness, by a complainant, then it can be a complaint. But every subsequent statement given by the complainant is 161 CRPC a statement, my lord. Otherwise, it gets hit by 162 CRPC.
That's a different story. Okay. Yes.
My lord, give me some. I'll also file the written submission.
Yes. Yes.
Obliged.
Yes.
My lord, 2 weeks time, my lord. 2 weeks. 2 weeks.
2 weeks. Okay.
I'll have 2 weeks and then I'll send it.
In fact, I made my submission brief thinking that I will sneak in and attend the other case. I missed it actually.
Entry model, sir. Entry model.
Entry will continue till the judgment is pronounced.
So, my lord, 2 weeks I'll file the.
Yes.
Item 1.
1. Adjourn. August.
12.
No, what is 1, by the way? Unnecessary cases are pending. Mr. Ragada, just see. Item 1, at least minimum this thing is required.
Fair question.
Charge sheet has been filed?
My lord. Charge sheet file. Nobody appearing, man. 22 case.
What to do if we dismiss in default, like an application will be moved?
My lord.
And item 1, you don't come and pass over. Then
22. Application was 22.
22.
That is the reason I was thinking that 22 matter or every fresh matter will finish.
Lordship gave the long margin.
But see, these are it's burden in the institution, spending unnecessary. Huh?
22 dismissal is in left.
22 pound?
Dismissal is in left.
21 matter. This much only.
22.
Just see on merit, you will see. We'll dismiss it. If there is something, we'll keep it. If there is nothing, then we'll dismiss it for default. Maybe the lawyer might have realized that there is nothing.
Quashing of cognizance, lordship, there is no such matter.
Cognizance.
Prime execution clearly made out, lordship disposal.
Right on. Why we have this petition? Petitioner has challenged the order dated 8/8/2022.
Sir, 3, on page 30, on the ground that the petitioner only an employee of that so-called company, and the name of the petitioner, if was not reflected in the FIR. Subsequently,
Charge sheet, what has come against you?
Yes, sir. Charge sheet has.
Radhamon Reddy. You are
Yes, sir.
Radhamon Reddy. Come to the charge sheet.
Yes, sir.
Come to the charge sheet.
In the charge sheet, you only stated that the petitioner is an employee of that company.
Read it.
Yes, sir. That's right. Rani page 27, yours.
There.
But you got it?
Yes, I am there. Read it.
Notice.
Yes, Mr. Dr.
Order the statement called for my lord, but in fact, the statement received charge sheet is there, my lord. Another date will be given, my lord. Another date will be given, my lord.
On then, Mr. Raghuda, then constable 6 time to.
Notice has already been issued, although they appear, but not.
Let me see 161 statement and all.
Yes, sir.
Whether any involvement of this accused is there or not. Because the main accused is some Bishwal.
Yes, even though the complainant has not stated anything about the present petitioner.
You must be there with Mr. That Bishwal and cheated people. Let us see the statement.
He was working in that way, my lord.
And yes, next.
61.
My lord, petitioner challenge the convenience order dated my lord 28/21 my lord. My lord, this case is case and a counter case also. Both family are near to each other. This house closely they are call for pouring water in rainy time.
Informant already appeared, my lord. Vinay Kumar Mahanti, my lord. First of all, he is
short for adjournment.
मतलब लास्ट वीक जे सन नेले टाइम होते कहलेनी मु दिन जाको बसछि आगे लास्ट डेट रे विषय टाइम नहीं
When he mentioned, I said the same thing, therefore it was not adjourned. Otherwise, I would have adjourned it. As requested response for the petitioner, please again learn on कब डेट किया था? एंट्री मॉडल है क्या?
एंट्री मॉडल अछि नहीं मतलब कहि देथिले मु सब आस पूरा 11 टा रे बसछि
no entry model right on 21/2/2023 notice was issued and an interim notice was issued and further proceeding in city case number 611 of 2021 was stayed. The matter was taken up on 2/4/2024 and the petitioner sought adjournment. When the matter is taken up today, again the petitioner has sought time, to which the opposite party number 2 opposite party number 2 is vehemently.
No, no, he is the petitioner. I am a petitioner, my lord. I am petitioner. Opposite taken time.
Acha,
He is praying for time.
Okay, got it. At the request of opposite party number 2, entry mode to continue.
Yes.
Entry mode to continue. I thought you are the opposite party, so that I wanted to vacate it.
Time टा नला petition को inform करते ले
That you tell he is your friend.
नहीं नहीं.
Yes.
62.
Result. But I am there virtual.
Yes.
So here, the petitioner is aggrieved by and has challenged annexures 1 and 1 by 1. Facts are like this.
Opposite party number 2, you are agreeing? Ready? Ready?
Hearing urgent to get.
Mr. Punda is asking for time.
My lords, he will ask for time. I was the IO in a case. How can I become an accused in a protest petition? I fail to understand. And if your lordship will look at annexure 1 and 1 by 1, your lordship will be surprised as to how judicial officers can pass such orders. Let him take time. I don't know. Let it come after vacation.
Let it. Entry mode to continue.
My lords.
At the request of opposite party number 2.
Obliged.
63.
Matter against the order passed by the London magistrate by not allowing for compounding of offences. Matter impugned order is at page 47. The entire order sheet file, that is annexes 7, but the relevant portion is page 47. The order dated 20th July 2023. The background of the case is that the check amount was 17 lakhs.
You are the accused.
I am the accused. The check amount was 17 lakhs. And the case was filed, notice was served, and subsequently case was been filed. Upon receipt of the summons, there was amicable settlement outside the court. Pursuant to that settlement, I transferred 7 lakhs in the mode of RTGS. And 10 lakh demand draft I deposited before the Honorable Court trial court. That thereafter the complainant changed his version, demanded interest over the check amount. So neither he received the demand draft nor returned the amount which I have been deposited in the RTGS.
So check amount is 17 lakhs.
17 lakhs.
7 lakhs you have paid.
RTGS.
And 10 lakhs you gave the
demand draft. I have annexed that demand draft also.
How much he is asking now?
He is asking a 17 lakh or total interest over 17 lakhs.
How much?
That amount mention करनी. से तथापि कौची जे मते टोटल 23 लाख टका दियो बोली.
When the when the check was issued?
2012.
Okay, 2012 you used the money.
And previously, no, what I am saying. Previously, another demand draft was filed in term of that, and with regard to
when 138 case was filed against you?
2012.
Now, when you paid this money?
7 lakhs. I'm giving the RTGS data. 18/8/17 page 41
5 years after.
5 years after the settlement, the matter was referred to the mediation. In the mediation, he agreed upon the complaint.
Where is the mediation report?
Mediation report is not with me.
Show me mediation report.
I can produce it.
Bring the mediation report. On that basis, I'll dispose it.
Yes, I will produce
if
it.
He has agreed, he can't disregard the mediation.
Exactly. And previously
there is no mediation and orally he has agreed, that then there is something you have to pay. After 5 years you are settling, then that judgment, Supreme Court judgment is there. At what stage, how much you have to pay extra?
Yes.
And that basis you have to pay.
Yes. And previously I had
if there is no mediation report. If there is a
mediation report, yes, your lordship is correct.
Bring the mediation.
And 2017, I must say, prior to 2017 also, I had filed another application seeking permission for compounding. In that case, the complaint.
Okay, you file, Mr. Mahapatra seeks 1 week adjournment to place on record the mediation report on the basis of which.
Your Lordship may say the mediation report or mode of compromise.
Mediation report or the settlement.
Yes.
And the settlement terms.
Yes.
Settlement terms on the basis of which he alleged to have paid 7 lakh to the opposite party and prepare a demand draft of 10 lakh, which was not accepted by the opposite party. Okay. Please the matter.
My interim order there.
Interim order to continue. Yeah.
65. Should be mentioned in the morning. 64. 65.
Yes.
65. Madam.
You mentioned it, na?
Opposite party.
Urgent. He has mentioned it.
After that. After that. No interim order.
No interim. Okay.
68.
68.
I am for the opposite but not to my lord. My lord, I am for the petitioner, my lord. I pray for next week, my lord. My senior is accommodation. Along with the CLMC 11/20/23. This is counter case.
Urgent he is asking.
That is Sangaret Asu.
Who done?
11/20/23.
What is that?
Counter case. Initially the present informant.
Okay, counter case.
Counter case. 11/20/23.
72.
You filed it, right?
They are all heavy man.
This one and revision. That's right.
Department is come with a affidavit just now.
Hmm.
So I have not gone through it. If Lordship will give some time, otherwise because specific date was fixed today. So just before 5 minutes they are coming, I have just not gone through also.
So, let them file the affidavit. I'm ready.
He is not ready. That's what he
So,
said.
sir, actually, if you also look at the last order,
Yeah.
my anxiety is, I think my friend is quite generous enough. Actually, I have seen him for a long time. He's quite fair also. Sir, more than 5 months have passed.
I know that's.
The vessels has been kept there. Now the crew members are without even drinking water. We are requesting the customer authority to provide some drinking water to them because they are like in a COVID situation. In the ship, they are there without food, anything else. So that's not a pity.
I don't think so because
But,
yes, as regard to the seizure, court has passed the order.
let me clarify one thing. Sir,
That court.
another important
These are the minimum thing.
Yes, so I am fairly considering if this situation it should be revoked. I am considering by my lord. I don't know, but my learned senior has passed the message. Then immediately I ask the officials
because he says therefore you have to take.
But
otherwise you will never take this kind of thing. Unless there is something.
But my lord, what I yesterday what happened in the court, suit, they are saying that this another person filed the erroneous suit and this company is a dependent.
So far as now the grievance is raised by Mr. Mishra. Do you want a judicial order or will you correct it? Today itself,
but the CP is the custody of Paradip Port.
But whatever you are the investigating agency at your instance, they are retained. You have to make sure. Because see, these people, how can you not give water?
Definitely. Without food, without water, it's quite, yes, I am considering the court. If the situation is so, then
you make sure that you send the message.
From our side, I am assuring that court that all sort of extent can be given. As regard the food and water is a minimum things for the.
That is not there, then no discretionary relief or.
But I just clarify from my senior, who has restrained you?
Interestingly,
speak to him.
Interestingly, Your Lordship clarified in the last order.
Right.
What is the exact mind of the court that has been reflected in the order itself? What they have done now,
each one of the crew members were taken out of the ship. Interrogation started. And one of them had been beaten black and blue. I'm telling in the court itself, I got this first-hand information.
This is very.
That interrogation is over since December. It was over long back. Now they have started, and it was told that some signatures have been taken from the crew members. I don't know what letter they have taken and what writing they have taken by force. The reason being, we have committed the offense, we know everything, the owner knows everything, like that.
See, if that is the case, you in affidavit you file an application. We'll take care of that. If that is the case, then no.
Let them file affidavit. I don't have any
only thereafter.
I don't know what allegation is coming.
That is in this proceeding only you file by way of an affidavit, give minute detail what has happened.
And one
minute
thing,
detail.
Sir,
With affidavit you give, then we'll take care of that.
kindly look at the last order, Your Lordship.
Yes.
Your Lordship wanted the valuation report.
Yes.
I wanted two things. One is the valuation report. On the basis of the valuation report, the proposition is the indemnity bond will be increased.
Correct, my lord.
And the cash security will be removed. And you have to satisfy me. How will you enforce the indemnity bond in this?
I'll explain that.
That is what we have.
Sir, my part, I'll explain to Your Lordship. Right.
Valuation report. Let the valuation report come.
My lord, I'm considering my lord. They're coming with the affidavit. I should go through it. Let's say keep it to Monday or Tuesday.
I knew that they'll
after
be
2 or 3 days after, but I am not asking the more time. As regards the valuation report is concerned, if this department fail to give, then Lakshmi may accept this insurance value. What this land court has
Then the issue would be they have to satisfy me insofar as the
enforceability.
Enforceability
And security of 100 crores of bond and 10 crores of this security.
10 crores they are agreed by that.
10 crores.
Your Lordship indicated in the last date
100
itself.
And I'll allow 457 subject to the arrest order by
Yes,
admiral.
that's right.
But in between there is another things I have to enlighten the court. The order passed in administrative suit is in force. Everybody is coming to file an order on Lulten application to impeding is a party.
It doesn't matter whatever.
And this
I'm not
suit is
concerned.
going on.
I am only concerned at 357 application.
Yes. Conjointly, our application and their application.
Subject to that order. Subject to that order.
But
they can't take it.
But my lord, we have challenging the basic order which is pending for my lord. So my lord can pass both the orders.
But it will have no bearing on that.
Yes.
That is independent and subject to outcome of that they will do whatever they want.
Pass order, pass whatever.
You please give me the valuation report.
Yes, Lakshmi may give another because what affidavit they are coming. Today affidavit
Valuation report is not there.
Forget about the affidavit. Let them give the report.
No, valuation report is given.
Yes, yeah. What my learned friend is saying that they are coming with a written instruction that the coaching everyone not cooperating them. That's why not getting valuation.
Right.
No value is available. If that's so, then we have to accept. There is no alternative.
This is one.
Whatever valuation is given insurance, this is the only document we have to lay. No option with us. So that's why I'm telling. Today is a Thursday. Let's may keep it to Monday or Tuesday, 30th or 31st.
Yes, sir. Decide whether Monday or Tuesday.
Monday or Tuesday.
And by the time you file that affidavit out.
Yes, what allegation they have, let them file the affidavit. And a copy may be served prior to that. Then I can.
Your Lordship may have it on Tuesday. Your Lordship may hear us on the quantum as to how a bond is to be enforced, Your Lordship.
That I can explain to you, Lordship, right now.
That part we can very well.
I don't have any hesitation. My learned senior argue about the hesitation. But thing is this: if valuation will be a criteria, if we are not getting the report and whatever report is accepted by the court below, which is before my law, and it is not a disputed fact, then we have to accept this. Then suppose the valuation will be given 115 crores.
Yeah, we'll
Now
keep
they
bond of 150 crores.
are coming that no, whatever 100 crores bond is given, we are not able to give, only 10 crores we are accepted in this.
No. Sir, no presumption.
No, I am not presumption.
Sir, if valuation increases, will give the bond at the increased
Simply
value.
you tell me whether that part, whether the enforceability of the indemnity bond given by a foreign national.
Yes.
that part should be heard today or Tuesday.
Tuesday. That's why
Very simple.
Sir,
And
sir,
meanwhile, you file affidavit Tuesday at 3 o'clock.
yes.
so you know, keep it in mind one thing. They don't dispute about the bond. They have accepted the bond. The indemnity bond, the order, they have accepted.
How will
because-
you indemnify? That is the question.
Exactly. But that was,
Indemnification is important for us.
sir, they knew that it
But
can be
because the
enforced.
department component
Therefore-
filing challenge the
Sir,
same
just a
order.
minute, sir.
Huh.
ମୁଁ କହିଦିଏ ଆପଣ କହିବେ ନା?
Yeah, sir.
If you're a central government, you speak first, sir. I'll explain.
It can't be. You are having liberty to speak.
Sir, they knew it is enforceable. That is the reason they have not challenged it before your lordship. They don't raise the question. Your lordship, out of anxiety, wanted that. What was that enforceability value? I have got the point to explain. Law is clear on the subject. This document guideline on mutual assistance of criminal matters, I have given to your lordship. That itself shows Vietnam is one of the contracting parties with Indian government, and all those countries which are also party to that, they have also mentioned. Reciprocation is there. It can be enforced in India and also in abroad, wherever this document has been signed by both the parties. Right? Section 105 of the Criminal Procedure Code explains everything.
Then it is enforceable. Now the valuation is
My lord,
the only.
what about our application there? We have challenged what my land senior submitted. The counterpart to that I am submitting our application 93 of 2000. Sierra Leone 93 of 2024 is the same position. We are challenging the order passed by the land court below. That it is paramountly wrong. It is amount to be set aside because the different region was given.
No, because, yes, because, tell me the ground, sir. I'm ready to meet.
So yes.
Disposal.
So both the case can be taken analogously, and their application will
Sir,
dispute, our application will dispute.
Your lordship, after hearing has passed
The
this
only
order.
thing what is remaining is the revision petition.
Yes.
The revision petition, we will hear it and finish. It should not take more than 5 minutes.
Yes.
Unnecessarily, we are wasting time. Less than 5 minutes it will take.
So interestingly, yeah, my friend also will agree with me. So the box was noticed, attached by magnet to the crane. We bring it to the notice to them.
Yes.
So if we have kept it, we could not have brought it to their notice. And this was not meant for India, sir. Even if somebody has kept it, it was going to Denmark. It was not unloaded. You have never seized it because of that.
In the land.
Yes. We are only to take the material and go.
Tuesday, 3 o'clock.
Monday.
Monday, huh? Monday.
Monday, sir.
Monday is possible? Possible?
Lots of matter had already there.
Huh.
Monday, Tuesday, long hearing.
Acha, 2 o'clock?
2 o'clock, sir, please. 3:30 को मैं
Monday, Tuesday.
Oh, Wednesday.
Let it be Wednesday at 3 o'clock.
Wednesday, 3 o'clock.
Wednesday, 3 o'clock.
If the customs officer said it's a negligence, no question of liability, then themselves will give a report.
But you file the affidavit. That is very shocking, whatever you are
We
saying.
have served a letter to that effect in customs.
No letter. You
We'll
bring it in
annex
judicial
that.
record and send a copy. He is also shocked by hearing this. And give a copy so that he will give instruction.
Immediately I talk to the officials.
Yes,
So
you
not
can't do that.
Yes,
This
yes,
is
you know.
Actually,
you
my
can
friend,
carry on investigation, we do whatever.
Yes,
my friend is very fair enough. He would have agreed today, in fact, but for the officer side, pulling him like.
We are binding with some.
No, but you have got your own statute.
Let us see, the Wednesday he come and concede whatever you are saying.
No, he should go to the Supreme Court some days.
After your encouragement, he may do that.
I'm following, sir.
Don't follow me.
He's our guide.
Everybody follows him.
Yes. Everybody shows the art of that. How can it be good?
Okay.
Pardon, my lord. Pardon, my lord. Item 68, interim order is there, man.
Interim order is there, they'll continue. Don't worry. Yes.
Revision matters. Yes. 73.
Revision.
Revision.
73.
73.
And whoever is ready, at least come forward at least.
Number 88, I am ready.
88. Chalo 88. You are ready? Shevanta Korea come.
73 is here, my lord.
73. Are you ready? Huh?
Yes, sir.
Come forward then. Yes. Yes.
Let,
you. Fine.
it's a confirming judgment.
Yes.
Appellant, petitioner.
What are the offenses?
Well, petitioner was initially he was charged. He along with two others, they faced trial for charge under section 341, 323, 325, 294, 506, 34 IPC. Allegation that while the informant was going on the way, there's two other accused persons they caught hold, and this present petitioner, number one, Mazhar Hussain, he assaulted by means of a stick. That is, and he
there were three accused.
Three accused persons initially they were there. The trial court acquitted two persons and convicted this and also acquitted this petitioner, accused number one. For other charges, were convicted under section 325 and
323.
And for sentenced him to 6 months.
Fine.
And fine of rupees 2,000. Whereas for conviction under section 323,
no separate.
No further sentence. He preferred appeal and preferred mallet in appeal. This order of conviction was sustained. And my contention before the appellate court and my contention before the Hon'Ble court in the revision application is a mallet two contention. One is mallet that there is a inconsistency in the evidence of the witnesses regarding the injured who has stated that he was assaulted brutally, but he has sustained only 2 injuries. That is one contention. Second is that the injury report, which is a doctor who has opined that he sustained 2 injuries, out of which one is simple and another is grievous. That X-ray report is also not produced before the court to sustain the injury. To substantiate the grievous injury. And my lord, thereafter another thing that there is a case and counter case. Counter case is didn't take into consideration who are the aggressor. That is the different. That pleading was raised before the appellate court, but in fact that is not. My now in this revision application, my lord, my whole contention before this Hon'Ble court is that only the injured, Dr. PW7. Well, at first, your lordship may kindly come to running page 23 of the appellate court judgment, paragraph 8. Doctor who examined paragraph 8, PW7 on 14/12/97 on police requisition had examined PW2 and found PW2 is the injured.
Yes.
Lordship got it, my lord.
Para 8 na?
Paragraph 8, running page 23. Internal page 6 of the appellate court.
PW7.
Yes. PW7 on 14/12/97 on police requisition has examined PW2 and found one lacerated wound of size so and so on the middle of the forehead and one swelling of size so and so on the back of the fifth metatarsal bone right side. PW7 opined that the lacerated wound on the which is on the head is simple in nature, might have been caused by the hard and blunt weapon, and opine swelling to be a grievous in nature, and the same might have been caused by the hard and blunt object. PW7 has approved his report by Exhibit 3.
Paragraph 9, my lord.
And then paragraph 9. The evidence of the injured PW2 that he was assaulted by the appellant by means of lathi on his forehead and his right hand gets ample support from the evidence of the doctor. He had found one lacerated wound on the forehead of PW2 and swelling on the back of hip.
How many months?
It is only.
How many months you have already undergone?
I have already undergone in the appeal. In the revision mallet, he was in custody.
Tell me how much.
Since 6th April 2011, he taken into custody. during appellate period. And during trial period, my lord, I have no idea from the LCR. It can be
Custody,
affected.
tell me when you got the bail.
I
Tell me the custody, but that's all.
around, my lord, 5th April, I got taken into custody. Thereafter, I taken into custody from the after the appellate court judgment from 6th April 2011. Another point, my lord, the open of offense.
You cross through the first point.
Oh, April ମାସରୁ ରହିଛି ପରା।
April ମାସରେ କେତେ ଦିନ ଆଜି ରହିଛି?
6/11
6/11 ତାପରେ
April 6/2011
କେବେ ବାହାରିଲେ?
ଡେଟ୍ ଅଫ ଅର୍ଡର ସିଟ୍ ନାହିଁ ବୋଲି ମୁଁ ବୁଝୁଛି। ଅର୍ଡରଟା
ସେତିକି କୁହନ୍ତୁ, ଆଉ କିଛି କହିବେ?
ଅର୍ଡରଟା କପି ନାହିଁ ମୋ ପାଖରେ।
And 6 month sentence, if you have already undergone sometime, I'll convert it to already undergone, finish it up. Unnecessary.
That is obvious.
Already undergone करो, fine पड़ेगी, fine पड़ेगी, काम खत्म करो। 323 एते टाइम करो। ठीक है, आप undergone अभी देखो।
ମୁଁ ଦେଖେ ଦଉଛି।
देखो दियो, फाइल दियो।
ଏখানে দেখুন।
যদি কম দিন যাইଛନ୍ତି undergone वाले फाइन टा पड़ जिवो। যদি বেশি দিন যাইଛନ୍ତି फाइन टा कम रहबो। बस सिंपल। नेक्स्ट आइटम चलो। जजमेंट रिजर्व आपण कोंतु, तार लिखि दियो तार।
23/6/2011 जाए
आपण साइड रे बसंतु ना। यू अलाउ
डिटेल कस्टडी पीरियड देख दଉଛି।
आपण सेठी बसंतु आसन। एठी देखो दिखाओ। नहीं एठी आपण एलसीआर अछि देखंतु ना। इमीडिएट सब देखि देबे। ट्रायल पीरियड रे केते थिले सब देखि देबे। एंड तार ऊपर लिखि दे उड़ कागज रे। यस चलंतु 74 yes
74.
Yes.
Petitioner has been convicted for 7 years.
376, my lord. Conviction,
376.
7 years.
7 years.
Fine,
Fine of
5,000.
5,000.
It needs hearing.
Madam?
It needs
It
hearing.
is hearing, my lord.
छोटो मोटो मैटर कोंतु।
हाँ, it थाउ।
राइट टिके आराम कहीं टाइम नहीं आज। आपण थाउ ऑन बोर्ड थाउ सुनिए हां हां
77 टा छोटे छोटे
77
354 is the conviction 1 year.
Oh 377 करो 77 77 354 convicted both the court sentence
1 year.
What have you done? Order litigation.
370 511, but converted 354.
76 511
511, but converted to
conviction is under section 354.
Show me the girl's statement.
Girl's statement is that my lord, the victim evidence is
I think
my lord, page 10, my lord.
PW8.
Criminal appellate PW8 huh?
Yes.
Come to page 21. PW8 is the unmarried girl of 17 years. She was rustic and for them the time of essence of life. The occurrence alleged in the last week of October. By then, the dusk was approaching earlier and going to drive so the bath is refreshment. It is not unusual. What is this here? Keeping in.
My lord, the trial court judgment, my lord. Your lordship can come to page 10, my lord.
10.
Paragraph 9.
10. Yeah.
10. The evidence of PW8 victim is that the occurrence.
1 minute.
Para 9.
Trial court, huh?
My lord, trial court.
The evidence of PW8 the victim is that the occurrence took place at
Page 10.
paper
Judgment page रहला 4.
page 11 ta.
11 ta ना?
No, that
11.
Evidence of PW, ठीक है, कौन तू? पढ़ो दूटा.
The evidence of PW8 the victim is that the occurrence took place at about 5 p.m. at river Dukan while she was taking her bath. According to her, the accused came and caught hold of her and made her fall and sat over her. It also appears from the evidence of victim that she raised alarm, as a result of which one Ullas Naik, that is PW3, who was taking her bath in the said river, came to her rescue, and after her arrival, the accused left the victim and ran out. From the evidence of victim, it further appears that the witness Ullas Naik was taking her bath at a distance of 15 to 20 cubits from her, and except Ullas Naik, none else were present at the time of occurrence. The said Ullas Naik has been examined by prosecution as PW3. From her evidence, I find that she was fully corroborated the testimony and the victim of the victim PWA, and stated that on hearing the cry of the victim, she went near her and found the accused Vijay.
Create corroborated
manner.
There is no penetrative section.
41, my lord.
341.
So for 341 month conviction, SI and fine 100. Default 5 days. 323, 3 months conviction and 10 day, 200 fine.
The substantive sentence is
Rigorous 1 year, 326.
26 to 1 year.
In appeal, 341 disallowed. Only 323, 326. I am here for 323.
and in the appeal, you are convicted at 323.
Yes, 323 and 326.
326 is converted to 323.
No.
323,
26 also.
326.
That's all right. 326 stars.
341 you are acquitted.
Yeah.
So show me the nature of injury.
Nature of injury was in simple.
Either it is 326 or 323. Show me the injury report.
Paragraph 2 re achi. Or the appeal, my lord, the paragraph 2, the appellate court of the case judgment. Page in the corner. Page in corner.
Annexure 2 or page 2?
Come to page 11.
Paragraph 2.
Yes, 11. Page 11. PW1.
Under appellate court.
Hmm?
Appellate court judgment. Appellate court judgment, my lord. Paragraph 2. The matrix of the prosecution case.
Injury number 3 is grievous
My
in
lord.
nature and caused by the sharp weapon. So the opinion of injury 1 and 2 might have been caused by the sharp weapon. And all the injuries are within 24 hours.
We don't do the injured witness and informant injured witness, and PDL 3 also the eyewitness to the occurrence. And PDL 4, 5, 6 are
the brother of informant.
My lord. And the post occurrence was 4, 5, 6. PDL 7 sky. PDL 4.
Who is the doctor?
Doctor is PW1.
1.
Doctor?
My lord.
Then
Doctor, my lord, the page 6, my lord. PDL 1, page 6 of appellate court, internal page 6. Appellate court judgment, internal page 6.
Yes.
First last, my lord. PDL 1, Dr. Bhimsan Meher has fully corroborated the injuries sustained by the informant. PDL 2, he examined the injured Mankhu Sahu, PDL 2, on police requisition on 13/8/2023 and found the following injuries. Cut injuries of size 1.1, 1.5 inch into half inch situated over the right eyes. One cut injury size half inch into half inch below right eye. One cut injury of size half inch into half inch on the dorsum of left
this
palm.
injury is creating problem.
My lord.
Third,
my lord.
Injury number 3.
My lord.
Yes.
That is yes, my lord.
And what is recovery?
A bhujali.
Weapon.
A bhujali.
Oh, then it corresponds to that 3. That's the problem. What you have used knife,
But exactly.
huh?
Prosecution witness are saying knife, but jelly is recovered.
Internal page 2, paragraph 2.
You just tell me injury number 3
My lord.
is caused by what?
Only written by sharp weapon.
Sharp cutting weapon. Both of them can produce the matter the engine number 3, either bhujali or knife. But
Se knife pocket ro kadi mari chota knife.
we do paragraph 2. I sustained pain in
Yes, madam, how will you get out of it?
Eyewitnesses and also the injured witness and
There are
doctor.
corroboration and everything.
The petitioner is alive or not, we don't know.
No, that's the
We have
main
no
argument.
communication to them.
That's the main argument. Petitioner is alive or not, he doesn't know. So you verify it.
We sent a letter and it got returned back.
Written back.
Address not found.
Incident is of 2003.
2003.
What was the age at the time?
50.
He was 48.
48.
That time it was 48 means now he must be around
64, 65. No. 20. 63, 65.
Yes, Patnagad.
which police station is this?
Patnagad.
Patnagad. Then counsel for the petitioner submits that the status of the present status of the accused is not known to her, despite the fact that she has written letters. The same could not be served on her, served on him. Served on him. So she is not able to assist the court regarding the present status of the petitioner. IIC what? Patnagad is directed to verify the status of the petitioner and file a report on the next date of hearing. Next date of hearing. Copy to देखो तो अपन
Free copy man.
report on.
Free.
Yes. 76.
Published.
On behalf of Mr. Naik, I press on adjournment. On behalf of Mr. Naik.
It will be there in the list itself. I'm not adjourning. List ରହିବ ଯେବେ reach କରିବ ହବ କରିବ ଠିକ ଅଛି 78
After 2 weeks.
2 weeks. Yes. 79. Yes.
My lord, I'm assailing the conviction imposed by the assistant sessions judge and confirmed by the appellate court.
Now, what is the file? Yes, what is the offense?
324, my lord. 324.
Was convicted under
3 years.
section 324 for
3 years.
3 years rigorous and
And
reduced to 1 year imprisonment by appellate court
324.
under section 324.
1 year.
Okay. Tell me what is your case? Is incident is of 2005?
Of 1999-2004.
2004. That time he was 25 years. Yes.
Yeah, page 12, my lord.
Page 12.
Paragraph 6.
Trial court?
My lord.
You are reading trial court?
My lord, my lord.
Yes.
Page 12, paragraph 6. PW1 is the informant and the most important witness of this case. He had identified the accused. His evidence reveals that at about on 9/9/4 at about 1:30 p.m.
accused Sunil Behra and one Manu Das of his village were quarreling among themselves. He intervened the matter. He intervened in the matter. He has stated that accused Sunil Behra abused him, saying freely language, and brought out a bhujali from his pocket and gave a blow on his head. And as he raised his hand, the handle portion of the bhujali hurt on his head. Further, he has stated that the accused gave
a bhujali in the pocket.
they are the villagers, my lord.
What?
Bhujali और knife भीतर किसी कुछ फर्क पा जाना है.
Bhujali in the pocket. Anyway.
And the accused gave a second blow on his right shoulder, for which he sustained bleeding injuries. He stated that Mohandas and Priyavarta Mahanti took him to Bhapur Hospital and allowed the information, my lord. Thereafter, my lord, Schedule 2, paragraph 5, internal 14, page 14, second paragraph, page 14.
Mohan Kumar Das.
Schedule 2, Mohan Kumar Das, who is a witness to the occurrence and he knows the parties. He has stated that the accused quarreled with him, and when Bhagirathi interfered in the matter, the accused brought out a bhujali from his garment and gave a blow to his head. Of the injured, and the injured saved him for raising his hand. Further, this witness has stated that the accused gave a second blow on the right shoulder.
And also there are many discrepancy in the evidences. First, there is inconsistency in the deposition of
then Schedule 16, my lord.
and
Schedule 16, my lord, page 16, Schedule 5 is the doctor who had examined the injured on the day of occurrence.
PW, doctor.
Schedule 5, page 16, my lord.
Yes, yes.
Schedule 5 is the doctor who had examined the injured on the day of occurrence and
Inside wound.
located one inside wound on the right shoulder, which has been caused by
which has been caused by sharp-cutting weapon. Medical evidence.
Three things are
Then there are two blows.
First blow, he raised his hand, my lord.
There is no injury.
No injury, my lord.
And
While the accused aiming his head, he raised his hand. No injury, my lord. So for second blow is shoulder.
That is being confirmed by PW5.
actually there are 3 injuries and actually there are
Schedule
3
1,
injuries,
2 and
but
5,
medical
But the doctor says there is only one injury.
yes, that is a contradiction.
No,
The
Schedule 1 से
informant-
कहूची. 1 and 2 both stated that when he are trying to assault him and he raised his hand, but that is safe, my lord. But subsequently the second injury blow, and he has sustained injury. That is there.
But where is 3 injury? Where will you get 3 injury?
Good pile.
Page 13.
ମୁଁ କହୁଛି Schedule 3 ରେ ପଢି ଦଉଛି ଆଉଥରେ.
In page 13, first line, further,
Okay.
further this,
Yes. Further, this witness has
witness
been
has been
further
further
cross-examined
cross-examined
on recall. The injured has stated to have sustained swelling injury on his head, and he has stated that he had also sustained what is-
ectomus,
on his forehead.
forearm.
Forearm. The informant is able to describe of a fire, but the fact does not necessarily diminish the authenticity of the fire. Informant.
Finding ହେଲା page 20, trial court page 20, paragraph 10. Finding.
Again, PW2 also said the same statement.
Finding the paragraph 11, 10, paragraph 10, page 20. Analysis of the evidence on record reveals that the accused had assaulted the injured by a bhujali, which is a sharp cutting weapon, to the right shoulder of the injured, which is a vital portion of a human body. So the facts proved by the prosecution clearly proves a case under section 324 of IPC. Beyond all doubt.
Shoulder to bachchi vital part from.
Yeah.
But in
Your lordship,
medical evidence, that is.
and he has been
There is a
acquitted
description about
307,
other two.
341, 294 acquitted. Only 344.
We'll convert it to 323.
There is no description about other 2 injuries in the medical report. And also the medical report,
Is
was, only the secondary evidence was
It's a
produced. The
Single
primary,
injury case.
the
It's
primary,
a single injury case. what I understood, is single injury case, but the injuries are corroborated by the eyewitness. as well as the-
Only a single injury. There were also
question of acquittal doesn't arise.
also
Now somehow you twist it and convert it to 323, then you are out.
another, the weapon of offense was not recovered. It was
Bhujan is
never
not-
produced before the court.
Bhujan is not recovered.
No. And also there was attempt to improvise the prosecution case by including PW 3 and 4. That is in page 26. And also
Are you harping upon an acquittal
set aside.
completely? Then okay, argue. If possible. Otherwise, we can convert it to 323 and already undergone detention, undergone with convict is set up in terms of imprisonment. How many months you have undergone?
I don't have that report. I
Take it
was
up.
only supplied with this brief and two annexures of judgment.
Do one thing, the soft copy LCR is there. You check it up. I think he might have undergone a month or so. We'll convert it to already undergone 323. Because it is a single blow case. Blow in the shoulder.
There is also
No recovery of Bhujali.
I have I don't have the deposition of defense and defense witness. I was appointed amicus.
All the cases, my lord, LCR return back and the barcode number is there, one it can do. Advocates and also the person- barcode number.
Can you give a pen drive?
I don't have.
No,
right
you give a pen drive
Fine.
and give it to Jyoti, and he will give you the copy of LCR. Then you can just assess if this is my prima facie view. If you can satisfy for acquittal, nothing like that. We can acquit also, no problem. Okay. And keep it
Thursday.
Give the pen drive and take it.
Okay.
415. 415 to 15, 430.
430.
DPC. No, DPC is
88.
Yes, within 5 minutes.
5 minutes.
Yes, so which one?
Item number 88.
88.
One point is a very important point. I think you have.
88.
I have prepared a written note of submission. Sign that.
Point go to.
Point, my lord, the injured has been injury report has been proved. Exhibit 2. There is no evidence that the doctor admittedly says that I have not identified, nobody has identified the injured to me. And one constable came with a requisition has not been proved. And no, I do not know his name. So now my point is that injury report which he has issued, whether it relates to that injured or not, that is absolutely because it was no police requisition, no command certificate, nothing else. So now that injury report, I don't dispute that what injury he has sustained or anything else. But the thing is that doctor has no personal knowledge about the person. He says that I examined so and so. Vinod Bhoya I examined. But he doesn't know him personally. So somebody has to identify him. Because it is a medical legal case, either on police requisition or constable will come with a command certificate. He will come and yes, this is the injured. And these are the documents that have been supplied. And on the basis of this, he has come to medical for treatment. If in other words, if he comes personally to the hospital, thereafter if FIR is lost, then police has to give a requisition to obtain a medical report. But here in this case, nothing. No requisition has been proved. Though IO says that I have issued a requisition, but no requisition has been proved. In the medical injury report, no case number.
Who had taken the victim to the hospital?
Some relatives, some co-villagers have taken.
But those were not the witnesses.
No, they are witness, but they have not. Nobody. Admittedly, doctor says that I have not. Nobody identified me the injured.
But if the persons those who have taken the victim to the hospital, if they depose before court saying that I have taken to the hospital, and their
No, no,
evidence can be read in corroboration with the
victim says
Hmm.
that I became unconscious at the spot. Then when I regained sense, I was taken to the hospital. Doctor says I treat him as an outpatient outdoor patient. Outdoor patient register has not been proved in this case. The injury report doesn't bear the signature of the injured, doesn't bear the case number. Doctor admittedly says that nobody identified the injured to me. No police requisition, though said that there is a police requisition, but no police requisition has been proved. So now under these circumstances, the doctor evidence become a hearsay evidence and hit under section 60 of the Evidence Act, because doctor has no personal knowledge. So in this regard, my lord, in 32 years back, I argued a case before this honorable court, and this is the judgment on same point.
convicted under 324.
323, 324. And initially there was a 2-year sentence, and subsequently it was reduced to 1 month SI under section 323 and 1 year under section.
How much you have undergone?
I have not seen, but your lordship may have a glance, because this is the this judgment said because if the injured report has doctor has not identified and injury report has not been proved properly, so that it will not relate to the injured. So this evidence cannot be taken as a.
Which paragraph?
My lord, your lordship may kindly see paragraph
3.
Paragraph 2. 2 is the discussion and the 3 is the finding. Admittedly, there was no other eyewitness to the occurrence PW5. PW2 is the witness to saw the appellant carrying PW5 from the cowshed to her veranda. PW3 is the neighbor appellant. And my lord, your lordship, there are several injuries come to the relevant line, my lord. The line start with no, word no. Eighteenth line from the top, my lord.
Yes.
Word start with no. No doubt such injuries were very grave in nature. But the peculiar feature of the case is that the identity of the person examined by the doctor in respect of whom certificate exhibit 5 was given was not established in as much as one Dinabandhu Mahanti, homeguard, who had taken the injured to the hospital for the purpose of examination, was not issued any command certificate for the purpose, nor was he examined to identify the injured. As the person who examined by the doctor, PW7, the doctor has also not identified PW5 to be the injured person whom he had examined. There is as such no proof that exhibit 5 relate to PW5, that the learned session judge has then other. This is the point, my lord. This is the point. Your lordship may have a glance to doctor evidence, which PW2.
How this was dealt with by the.
No, it has not been dealt. It has not been addressed. But that is I have stated in my note.
So then we'll keep it as a part and related.
Yes, your lordship may have it
tomorrow.
No, this is the written note.
Let it continue. Huh? You continue.
So this point, because 32 years back, I argued this matter before Justice Helga.
We will now reiterate that.
Yes. So when I saw this point, then I was very much anxious to raise this point to you before laws.